Good afternoon. Hope everyone had a good lunch break. We are back for the continuation of the hearing in docket 2022-142-WS. It's the rate case application of Daufuskie Island Utility Company Incorporated. Let's take a roll call of commissioners. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair, Vice Chair Powers, Commissioner Thomas, Commissioner Carolee Williams, Commissioner Caston, Chair Belser, and with us virtually we have Commissioner Irvin. Witness Costello is still on the stand, and I believe we're with ORS cross-examination. Mr. Mustian, you may proceed.
Thank you, Madam Chair. Good afternoon, Mr. Costello. Excuse me.
Good afternoon.
I want to start with you about your recommended return on equity of it's 10.5% is what you recommend. Is that correct?
Yes.
Okay. And you don't base that on any cost of capital methodology, do you?
If you're referring to the methods that used by the cost of capital experts, no, I base it on my comparable average service lives and depreciation rates that were used by ORS and the company in the past cases.
So just to be clear, you don't use a CAPM or a DCF methodology?
No.
Okay. Have you ever testified as a cost of capital expert where you've used a CAPM or a DCF methodology?
No.
And one basis for your opinion as to why the 10.5 is reasonable is your comparison to other states and their standard methodologies. Is that correct?
Well, that's part of it. It's also because of how sensitive the earnings erosion is for small companies compared to the large companies within the proxy groups, and there's just no comparison.
Right. But one basis, not the entire basis, but one basis is the methodologies that you cite from Massachusetts and Connecticut and Florida. Is that correct?
Those are part of what I included as what other states are doing with respect to rate of return on equity.
And so I believe I'm showing you right now what is Schedule A3 to the application, and I believe that you testified earlier that you assisted in preparing those documents. Is that correct?
Yes.
And so on that A3, you reference Massachusetts DPU return on equity, Connecticut DPUC formula, and the Florida PSC leverage graph formula. Do you see that?
Yes.
All right. So let me start with the Massachusetts law. Are you familiar with how Massachusetts went about adopting its range of 11.5 to 14.5?
Generally.
Have you looked at what the basis for that is?
They generally take a look at what they've allowed for the larger utilities, and I believe it was Aqua America and maybe Connecticut Water. And then in their decision for small companies, they used an average and adjusted for small company adjustments to increase the rate of return.
Okay. Or when you're referencing, would it be Aquarian?
I believe it was Aquarian of Connecticut, yes.
Okay, so I'm not talking about Connecticut right now. I'm talking about Massachusetts.
And I'm talking about Massachusetts as well. Maybe Aquarian in Massachusetts may be one. I'm trying to remember, and I'm not 100% sure.
Okay. Well, we'll start with this way. So this was a document that the IUC produced in Discovery, which is 220 CMR, which I believe is Code of Massachusetts Regulations or something along those lines, 31.00. Do you see that?
Well, I see it, but it's hard for me to read it.
Madam Chair, may I approach? Mr. Costello, are you familiar with this document?
Generally.
Okay. Did you review this document when looking at your proposed return on equity and the comparison to Massachusetts return on equity?
No, I don't think I did.
Okay. So, Mr. Costello, if I can turn your attention to page 2. And this would be Regulation 3103, and it says, except where the department may otherwise determine in specific cases the allowed return on equity may not exceed 14.5% or be below 11.5%. Did I read that correctly?
Yes, and I believe that's what I recognized in my exhibit and testimony.
Madam Chair, again, may I approach?
Yes.
Mr. Guastella, what I have handed to you is an order from the Massachusetts DPU from dated October 16th, 1997. It's 181 PUR 4th 82. Do you see that?
Yes.
And if I could turn your attention to the very last page. And do you see where it references the 14.5 or the 11.5 number?
Yes.
So, subject to check, would you agree with me that this is the order that established that 11.5 to 14.5 range?
Subject to check, I would.
Okay. And if this order was 1997, it's been about 25 years since the Massachusetts DPU established that range, has it not?
Yes, if this is correct, that's correct.
Okay. And Mr. Guastella, if I could turn your attention to page 2 of that order. You'll see there's a paragraph or a section 3, and at the bottom of that, the very last sentence, it says, the department proposed this amendment with the intent of aligning ROEs more closely with the changes that have occurred in the financial markets since 1985, and to bring water utility ROEs more in line with those ROEs granted in recent years to gas and electric utilities. Do you see that?
Yes.
And Mr. Guastella, would it surprise you to know that this commission recently granted a return on equity of about 9.3% to a gas utility?
No, it wouldn't surprise me.
Mr. Guastella, if I could ask you to turn to the next page, which is page 3. And there it says, if you'll read along with me, most commenters state if the minimum ROE were reduced to 10%, water utilities would in all likelihood stop using the optional cost of capital formula and seek higher rates of return through the services of outside cost of capital consultants. According to them, this would increase the frequency and complexity of rate proceedings and add significant costs that would ultimately be borne by ratepayers. Do you see that?
Yes.
And if you turn with me, this will be the last time I think I ask you to turn. If you'll turn with me again to the last page, where there's a reference to footnotes, and it says one commenter estimated that the services of a cost of capital witness would cost between $20,000 and $40,000. Do you see that?
On the very last page?
On the very last page, yes, sir. It's under the section called footnotes.
Yes.
Okay.
For me, that was the second to last page, right?
Oh, I'm sorry. My apologies. So first, let me ask you, Mr. Guastella, how much have you charged DIUC for your consulting in this proceeding, not in the other proceedings, but with respect to this specific rate case?
With respect to rate of return or overall?
If you can break it out, then that would be great. If not, then how much in total?
Well, with respect to rate of return, very, very little, because we didn't go through one of these CAPM or DCF methods. Overall, I'd have to look at numbers. I don't remember off the top of my head what the overall. We included, I believe, $400,000 for this rate case originally, but I think we may have exceeded that because we've had about 400 discovery requests and generated about 3,250 pages worth of discovery. So I'm guessing our estimate of 400,000 was understated by a lot.
Okay. And how much are you charging DIUC per hour?
I charge $390 an hour.
But turning back to Massachusetts, I mean, you would agree with me that they have a scenario where there's a formulaic ROE, but they don't have to expend the resources on an ROE witness. Is that correct?
Yes,
Okay. But here you are seeking recovery of rate case expenses that includes the cost of you coming in and testifying for a higher ROE. Is that right?
yes, of course.
Mr. Guastella, let's turn now to Connecticut, if we can. May I approach?
Yes, sir. Mr. Mushton, do you have a copy that you can give his counsel? I failed that on the
My
other.
apologies. Be happy to. Beg the chair's indulgence. Let me provide those. All right. Thank you, Madam Chair. My apologies for that.
Thank you.
Mr. Guastella, let me first just point you to the first page of this. This was a document that that DIUC produced us in discovery related to your ROE analysis, and this is a 2013 order from the state of Connecticut. Do you see that?
Yes, I see it. This is investigation for streamlining the rate-making process for small water utilities.
Okay. And is this a document that you reviewed when you were coming up with your 10.5 number?
Yes, part of it. I didn't have to read the entire document to come up with a 10.5.
Okay. If I could ask you to turn your attention to page 3. And you see there's a settlement agreement. This is basically how they determine their ROE. Does that look correct to you?
It says they requested a settlement agreement from the parties, yes.
Right. And here there's the Aquarian water, I think, that you reference, and then Connecticut water. Do you see that?
Yes.
Okay. And you'll see here it says, and tell me if I read this correctly, that the base allowed ROE average for Aquarian excludes any bonus incentive or penalty adjustments made by the PURA. Is that correct?
I'm sorry, where are you reading?
This is paragraph 1 underneath the chart, where it says Aquarian water and Connecticut water base allowed ROE.
Yes, I see that.
And it says that the base allowed ROE average for Aquarian water and Connecticut water excludes any bonus incentive or penalty adjustments made by the PURA to the allowed ROE for the individual company. Is that correct?
Yes.
Okay. So if you look with me up at the chart, it looks like Connecticut, and tell me if I'm wrong, but Connecticut uses an allowed ROE of 9.85%. Do you see that?
That's what they allowed for Aquarian water.
Okay. Well, I think they may have allowed 9.95 for Aquarian water. Do you see that in the very first table?
Yes,
And then they used a Connecticut water of 9.75.
correct.
And then they averaged those two to get to a 9.85. Do you see that?
Yes.
Okay. And that was, as you pointed out, that was what was in the settlement agreement, correct?
Without going through the whole document, I think that's what was settled for those large companies.
Okay. But if you look down at the footnote at the bottom, do you see that?
Yes.
And it says At the time the settlement agreement was signed, the current allowed ROE for Aquarian water was 9.95.
Yes,
Recently, this was changed by the decision dated September 24th, 2013, to an allowed ROE of 9.63, 9.13 base ROE plus 0.50% bonus.
yes,
So, Mr. Guastella, going back to the schedule that you put together in the application, you came up with a Connecticut average large company percentage of 9.69%. Is that correct?
yes. I believe, however, in Discovery, we adjusted that to reflect the 9.63.
Okay, so you acknowledge that the formula that you used in your application was wrong.
The formula wasn't wrong. The number was changed for Aquarian, so we adjusted what the number was.
You used the wrong formula when you put together the application, correct?
No, we used the same formula, but what we did was adjusted the, one of the components of the formula.
Well, when you did the analysis for the application, you based that off of the 9.95 for Aquarian, correct?
The
9.95 for Aquarian.
I believe it was the 9.65 that we came up with, 69, which was the average of the 9.85, which was the average of 9.85 between Aquarian and Connecticut. So the 9.95 is what we used for Aquarian.
And that was wrong, wasn't it? Because the footnote specifically says that they had adjusted it down to a 9.13 base ROE.
And we adjusted that, I believe, in the,
And so my question is when you did the calculation in the application, you were wrong.
well, it was wrong because we didn't adjust that number, correct?
So, okay. All right, let's look at Florida if we can. And Mr. Guastella, what I'm showing you again was a document that was produced to us in Discovery. This is a May 25th, 2022 memorandum issued by the Florida Public Service Commission. Do you see that?
Yes,
And this is a document that is described as Water and Wastewater Industry Annual Reestablishment of Authorized Range of Return on Common Equity for Water and Wastewater Utilities. Do you see that?
yes,
Now, is this the document that you looked at when preparing your analysis of the Florida PSC formula?
yes, I believe this was the calculation we made. I believe Mr. White made the calculation, but this is the formula I think we based it on.
And I'll turn your attention back to the application, and I apologize. You have a copy?
I have a copy of the application.
So on the application,
Mr. Muchton, could you adjust that on this? Thank you.
yes, ma'am. Thank you. So on the application, you reference the leverage graph formula, which you say is 6.05 plus 1.8 divided by equity ratio equals ROE. Is that correct?
Yes,
And so am I correct that you get to your 8.82 by taking the 64.9% equity, you say 1.8 divided by 64.9, and then you add that to the 6.05%. Is that correct?
could you repeat those numbers again?
Certainly. Okay. So the formula you start with your base of 6.05. Is that correct?
Yes,
Okay. Then you do the parenthetical, which is you take 1.8, which is the ratio, divided by your equity, which in this case would be 64.9, correct?
yes,
And then that gets you the 8.82 total, correct?
yes,
Okay. So number one, the Florida number reflects a significant decrease from what you are recommending in this case, correct?
it's less than what the 10.5 that we're recommending, yes.
Fair enough. All right, then let me go back to the Florida order, and if I can turn your attention to page 6 of 10 of that order.
I have it.
And do you see there it says 2021 leverage formula currently in effect? And there is the formula. I'll see if I can try to do this side by side, but you can see 2021, there's the 6.05 plus 1.80 divided by equity ratio that you used in your application. Do you see that?
You're on page 6?
Yes.
You mean the 2021 or 2022?
Well, I'm looking right now at the 2021.
Oh, yes.
Okay, so you used the 2021 formula when you were coming up with your Florida comparison, correct?
Yes.
Okay. If you look through the 2022 formula, it's different, is it not?
It is different. And when we were preparing the filing, we probably had the 2021. I don't remember whether or not we had the May, because we were doing the filing before we were preparing the numbers before the filing, but we did use 2021.
Okay. So that's another error there that you should have used the 2022, is it not?
Well, it just would have been updated. I don't know if it's an error, because it doesn't make a significant difference whether, you know, we're using an 8.82 or some other number that varies off of 8.82 by a little bit.
Okay. But you haven't done that calculation, so you don't know what it would be.
No, my return on equity recommendation is a 10.5, using all of these numbers and basing judgment. For example, in Massachusetts, we filed for a small company and they allowed the 10.5 that we recommended. So even though we're talking about this range of 11.5 to 14.5, we had an actual utility, small company utility, that was settled, and they allowed the 10.5 that we recommended for a small company.
But at the end of the day, and I'm talking just about Florida, when you're doing your comparison to Florida, the number that's in the application is based upon a stale 2021 leverage ratio, correct?
Yes.
Madam Chair, if I could just have a couple of minutes to consult with counsel for DIUC, I may be able to move the next part of this along a little bit.
Yes, sir.
Meeting minutes and things like that. I should go through it again, authenticate each of those.
Oh, I'm sorry, is this not just copy of that, or what?
Yeah, so there's people on the course. Look at it before you get to it, so I can go through it.
Stipulation would be to leave casinos?
Yes.
Yeah, that's fine. I think the thing to do is, have him maybe,
What I think we just have to go through.
yeah, if you want to limit that, and have him count total number of pages and say casinos, that's fine.
Yeah, I mean, what I'm trying to do is
Oh, yeah, let's just count the pages and say, these are all your emails.
Madam Chair, thank you for your indulgence. Mr. Guastella, I've handed you what is a pack of emails that were produced to us in Discovery. Do you see that?
Yes,
And
I haven't been through each one, but I see the pack.
certainly, and I'm counting. This is about 12 pages, and in order to be efficient, what I was proposing to do was just to have you look through those, and if you could confirm to me that these are emails that you have either received or sent.
Yes,
Madam Chair, this time, and I will hand these up to the court reporter and have copies for the commission, but I would ask that these emails be marked as the next hearing exhibit and introduced in the record.
No objection.
Twelve pages, Mr. Mushin.
Yes, ma'am, 12 pages.
The emails, and these were produced in Discovery, is that correct?
Yes, ma'am.
Emails produced in Discovery of 12 pages will be marked for identification as hearing exhibit 4 and is received into the evidence of this case.
Thank you, Madam Chair, and appreciate council's willingness to work with us on that. Mr. Guastella, let's start, if we can, with the first page. Let me ask you first about the Compass South appraisal. When did when did DIUC or Guastella and Associates or whomever, when did you first engage Compass South?
it was in August, I believe,
Okay, so,
2022.
and
Mr. Costello, may I ask you to pull that microphone a little bit closer, please?
Sure.
Thank you very much.
And Mr. Guastella, if you look at that first email that was dated August 29th to you, there was some discussion in there about doing the analysis from Mr. Travis Avant. Is that correct?
Yes,
And who is Travis Avant?
he was one of the members of the Compass Group.
And so you hired them before your direct testimony in this matter was due. Is that correct?
I don't recall. I believe it was before the direct testimony was due.
Okay. But I believe you testified previously that you anticipated that the Office of Regulatory Staff would do an estimate and that you did not need to do an estimate until after you saw that in their direct testimony. Is that correct?
That's right, but we wanted to be prepared because there was very little time for us to respond to ORS.
Okay. And you also referenced a statement by Mr. Andrew Bateman during oral argument in the appeal, I believe in 2018, 2019. Is that correct? Where Mr. Bateman made a comment about ORS being willing to accept an estimate. Do you recall that?
Yes,
Do you know when that statement was made?
it was made, I believe, at the oral argument before the Supreme Court, South Carolina Supreme Court, and I believe that was in April of 2019.
Okay, so subject to check on the exact date, you knew at least since August of 2019, April of 2019, that you would need to do an estimate. Is that correct?
No, I thought, not only thought, the back and forth discussion between the Supreme Court Justice is plural, and Mr. Bateman was that the Supreme Court Justices expected ORS to do an estimate. And basically what they were saying was the company gave documentation, if I recall the words correctly, although scant, it was still documentation, and that should be a presumption of reasonableness. And they expected then, rather than ORS to allow nothing, ORS should do its appraisal and come up with a number. And if ORS came up with a number that was lower than the company's documented number, then the Supreme Court would have something to discuss. But ORS did not do that, and that was a problem for the Supreme Court justices.
And so it's your opinion or your belief that the Office of Regulatory Staff has the burden to do an estimate of a utility's plant and service and assets?
I believe that that's what the justices at the oral argument were expecting ORS to do.
Well, the record in that case will reflect what was said, and the order will reflect what the justices required. However, you were aware, at least in April of 2019, that an estimate was going to be an issue in this rate case.
I didn't know whether or not it was going to be an issue. I think what the court was saying was, and they reversed and remanded the decision, the second remand decision by the commission. They reversed and remanded it to the commission without accepting any of the commission's adjustments, which included the $699,361 adjustments, which included the Melrose plant. And there was discussion, that oral argument, specifically about the Melrose plant. And basically what the Supreme Court Justice was saying is, ORS should have made its estimate if it didn't like the documentation provided by the utility, by Daufuskie Utility Company. So I expected that that would have been something that ORS did, and it didn't. So we were prepared. If it didn't, then we would do that so that we would be providing, if we had to, and I'm not sure we'll have to, but if we had to go back to the Supreme Court, we'd be providing the estimate that ORS did not provide.
Well, if you thought ORS was going to do an estimate, why would you even hire Compass South?
In case ORS did not do the estimate.
Well, then why didn't you hire them well in advance of filing the application in this case?
Just didn't. We didn't think it was necessary to do it before.
Okay. Mr. Costello, you also talked about in your testimony that part of the reason that you did not file a rate case previously was your understanding that you could not file a rate case while another was pending. Is that correct?
Well, we could not because it wouldn't have been realistic to do so. The issues that were pending in the case, the 2014 346 WS case, would have been the exact same issues that we would have been filing in the next rate case. So to have rate case expenses mounting for 7 years, and then during the course of that time file another rate case, that would have, for the most part, addressed the largest revenue requirement component issues, would have been another duplication and another round of rate case expenses. And I frankly don't know whether or not, if we filed for another rate case dealing with the same issues, how the commission would have reacted. Would they have wanted to have two separate rate investigations, two separate hearings running at the same time as the basic major issues were still pending before courts? I didn't think so. So I don't think it was realistic to do that.
Well, Mr. Costello, I want to turn your attention to your pre-filed direct testimony, page 7. Do you have that with you, or I could provide you a copy? It's on the screen.
No, I have a copy of the pre-filed direct
Yes, sir.
testimony.
Your pre-filed testimony.
Yes, I'll have a copy if you give me a second here.
Yes, sir.
I have it.
And at the top of the page.
Which page are you on?
I'm sorry, page 7. And you start that answer by saying, I am not aware of any precedent for filing another rate application while a pending rate case was in the process of an appeal to the court. It is my understanding that a utility must first exhaust its administrative remedies before proceeding with a rate filing that has the same major issues that are still under review by the court and the commission. Do you see that?
Yes,
So that sounds like to me you're saying that you're prohibited from filing a rate case while another is on appeal.
well, I said that's my understanding.
So your understanding was incorrect at the time you filed your direct testimony?
I don't know, if utilities are not permitted to file it, then my understanding is correct. If they're permitted to file another one, then they're permitted, but then as I say here, we'd be dealing with these same major issues in two cases pending and running at the exact same time. My opinion is that would have been an enormous waste of time and unnecessary.
Okay, but that was a choice that you made, not because you were legally prohibited from doing so.
Well, that was my understanding, and that was a choice we made. Yes, I made that choice to not have these customers pay, on top of $1.8 million, another whole round of investigation pending during appeals of the same case. At some point, it seems to me I want to protect the customers from excessive rate case expenses, and I wasn't going to go through another process where the commission could have told me, you're already incurring enormous rate case expenses, now you're filing for another rate case pending and dealing with the exact same issues. To me, that would have been completely unreasonable.
Okay, well, let me turn your attention back to the email packet that I've handed to you. And if we can go to the next page, which would be the third page in that packet. It's an email dated July 1, 2020. Can you let me know when you get there?
The first page I have is an email dated August 29th, and the next one I have is dated August 24th. Or is that just a follow-up from the first page?
So there should be and I apologize for that. So the first page should be the August 29th email. I believe the second page is just part of that first email. So okay. I'm looking at
the third page.
The third page is the July 1st, 2020 at 11:58 a.m. email.
I have it.
Okay, thank you. So if you look about halfway down the page and tell me if I'm reading this correctly, I'm 100% confident that we will succeed on all issues, including reparations. So far, I have succeeded on 100% of the issues. My rate case expenses have exceeded the $542,978, which is for work up to October 2017. There have been a lot more since then because of a petition for rehearing at the commission, and then a second appeal to the court, and now another hearing, and we're still not finished. Did you see that?
Yes.
So and then if you look with me down, it's about 5 lines down. There's a sentence that says, I plan on filing another rate case by the middle of 2021. Do you see that?
Yes.
Okay. So at least in July of 2020, you were already looking at filing another rate case in 2021. Is that correct?
Well, at the time I was hoping that this would be resolved by 2021, but apparently it was not.
Okay. And what made you delay filing the rate case until 2022?
Well, the settlement didn't happen until March of 2021, and there were lots of activities going on all of the issues, and a third round of hearings on the reparations issue. So we were still kind of, if you will, up to our ears in rate proceedings in the case that was still pending and remained open pending the appeal of the reparations. So my hope that we would have resolved this in 2021 didn't materialize, not because we didn't want it to materialize, it just didn't happen because there was ongoing investigations just to deal with the 2014 case.
Okay. Mr. Guastella, if I could ask you to turn to the next page, and this is an email dated January 7th, 2021. Do you see that?
Yes.
Okay. And there you say, so once again, we've had to press for action to proceed with the rate case. As I have advised before, I am 100% confident that we will get a favorable outcome, even though I think we will again appeal whatever decision the commission finally makes. Do you see that?
Yes.
So are you saying that if you don't get a favorable outcome, you're going to appeal whatever decision this commission makes?
That was my opinion at the time, and it turned out to be correct.
And, well, this is talking about the next rate case, is it not?
No, the court's decision, I believe, was issued in July of 2019. And we expected, at least I expected, that once the commission got a second reversal and remand on its decision, and the courts had not at that point in time accepted any of the commission's adjustments in the first appeal. It did not accept any of the commission's adjustments in the second appeal. I thought there was a realistic opportunity that the commission would then take a look at those decisions and come to a reasonable rate allowance. What happened, though, from July of 2019 until September, I think when the court's decision was submitted, we were anticipating the commission taking action. The commission didn't seem to be taking any action. So at this point, we had, as this states, we had to press for the commission to take some action, and I believe the attorneys for DIUC, I don't know whether they spoke or sent an email to the commission saying, can we set this for hearing? We were trying to move this along because we were in our 6th year or so, 5th or 6th year, and we were looking to move this along. So that was this was all about. At that point, if indeed the commission wasn't going to establish the cost of providing service, then we were going to, in my mind, have to go back to the Supreme Court, which we hope not to do, and I still hope not to do.
Okay. But at the time of this email, at least, even before the commission had ruled, you were already had basically made the decision that you were going to appeal that decision if you got a poor outcome.
I anticipated that we probably might have to, yes. I was warning one of the owners of the company is this is what might be happening. You know, they're interested in seeing what's happening. They've been living through never earning a return, having to advance to the utility hundreds of thousands of dollars just to cover cash flow for a small company that's been through, at that point, a 5 or 6 year rate proceeding. And these owners wanted to know, where are we going to go with this? And I was trying to let them know the worst case scenario, and the worst case scenario, unfortunately, seems to have taken place because the reparations was denied, and the 88.5% increase that the commission gave in its January of 2018 decision, that 88.5% increase covered the period from April of 2016 through March 1 of 2021. And that was not being corrected because eventually the commission rejected the reparations. And the appeal to the commission for reparations is for the commission to correct the decision that did not cover the cost of providing service. The owners wanted to know where this was going. I mean, they were living with a lack of rate case expenses, rate case increases, the cost of rate cases being way beyond what anybody ever anticipated or even asked for. And I have to be upfront with the owners. They want to know what's happening, and this is a memo trying to let them know that this might go even further. And unfortunately, it went further because now we're in a reparations appeal.
All right, let's go to the next one, which is February 25th, 2021. Do you see that?
The next one I have is May 20th, 2021. Oh, February 25th, okay.
See that?
Yes.
Okay. And here, about a third of the way down that, or 2/3 of the way down that paragraph, it says, because it has taken so long, we will also have the opportunity to recover all costs and revenues with separate surcharges for reparations and amounts to be included in the next rate case. As of now, I expect to prepare for the next rate case over the next 3 months for another increase to become effective on January 1, 2022. Do you see that?
Yes.
And again, the date of this email is February 25th, 2021. Is that correct?
Yes,
Okay, and so at that time, you were still planning on filing a rate case. If it was effective January 1, 2022, that would have been June of, or July of 2021, correct?
I'm trying to recall what I was planning and what was, it might have been anticipated. We had put in a request for reparations, and in February of 2021, that wasn't dealt with yet. So what was happening in March of 2021, there was a settlement that allowed the original filed 108.9% increase, but the parties did not agree to reparations, so the parties agreed that the issue of reparations would be dealt with subsequently, and the case remained open in order to adjudicate the question of reparations. And that would be, and I was hoping that we'd be prepared for the a rate case after that. However, if I recall the timing of this, the commission's decision to deny reparations didn't happen until significantly later, because from March 1 of 2021, the process of reparations before the commission, the issue of reparations before the commission began. And it began, and there were, believe there was a process that led up to a November 30th hearing where the attorneys presented arguments, and then it was subsequent to that that the commission came out with its decision denying reparations. But up until that point, yes, we were going to have to file for another rate increase, because the rate increase in the 2014 346 docket was based on a 2014 test year. We had been incurring other costs not reflected or included in the 2014 rate case, and those were just accumulating and accumulating, plus the rate case expenses were accumulating and accumulating. So at some point, I knew we had to file for another rate increase as soon as reasonable for us.
Well, let me ask you this, Mr. Guasella. So, and I might should have pointed this out previously in the earlier emails, but so this email is to 3 people. So I see Terry Lee, and can you tell me who Terry Lee is?
Terry Lee is the president of the company and the major owner, member of Daufuskie Island Holding Company. Daufuskie Island Holding Company is the sole stockholder of Daufuskie Island Utility Company. And Daufuskie Island Holding Company is an LLC with 3 members. Terry Lee is the major managing member of the holding company, and there are 2 other members of that holding company who are essentially owners as well.
And there are 2 other email addresses. One is D Hutt and one is R Shem. Do you see those?
Yes.
And could you tell me who those 2 people are, please?
Yes, David Hutt is one of the members of the holding company, and Ron Shemanowitz is the other member of the holding company, along with Terry Lee being the managing member of the holding company. Terry Lee is also president of the Daufuskie Island Utility Company.
And the 2 gentlemen you just mentioned, they are attorneys in New Jersey, I believe. Is that correct?
Yes.
And sometimes in emails you have referred to them as the New Jersey attorneys. Is that correct?
Yes.
Okay. But here you're advising the owners about the different issues that you've got, but you seem pretty confident that you're going to recover all of the costs and revenues as part of this appeal, all of the rate case expenses. Is that correct? Is that what you're advising them?
I'm sorry, I'm advising them that I'm 100% correct that we're going to succeed in court.
So you believe that you are 100% going to believe you're going to succeed?
I believe so, yes. In my opinion, I believe Daufuskie Island Utility, with respect to the appeal on reparations, is going to be 100% successful.
Is it possible that you will lose?
I don't think it's possible, but there's always that possibility, I guess.
So it is possible.
Well, it's possible.
Let me turn you to the next email. So this is dated May 20th, 2021. Again, this is to Terry Lee, David, and Ronald. And if you look at the second paragraph, you reference, I don't think the customers want to incur any further legal fees. Do you see that?
Yes.
So you're making the assumption then that the customers are certainly going to be required to cover all of the rate case expenses. Is that correct?
I believe the customers are going to have to pay rates based on the costs incurred, which include rate case expenses. The customers don't pay for rate case expenses. The customers pay for water when they receive water, and they pay for sewer service when they receive sewer service. They don't pay directly for any of the costs the utility incurs. What they pay for is the service they receive, and the cost of the service that they receive and the rates for the service they receive are based on an analysis of what it costs the utility to provide the service.
So do you think that whatever the rate case expenses are, the customers have to bear that amount?
It's subject to review, but as far as I'm concerned, the rate cases we've incurred were not attributable to the rate cases we expected to incur. I think I mentioned this a number of times. We expected in the previous case to incur a rate case expense of $191,200. I never, in a million years, imagined that the case would take 7 years and rate case expenses would be $1.5 million. Through no fault of our own, that's what happened.
But you certainly understand with your experience that there may be rate case expenses that are imprudent.
Well, there may be.
And customers shouldn't have to bear those expenses, should they?
And if there are adjustments that we believe are reasonable, we would make those adjustments.
Are there any expenses that you have, any costs that you have charged DIUC that you think are imprudent?
No.
So you think that everything that you have charged DIUC, you should be entitled to recover through rates?
I believe the customer should pay rates based on the costs that utility incurred that are reasonable, and the costs that we've put in our filing are costs that we believe are reasonable and reflect the cost of providing service.
Okay. Let me ask you to turn to the next email. This is January 19th, 2022. So again, in the first paragraph towards the bottom, you say, I intend to petition the commission for reconsideration, and then if denied, which I expect, appeal that decision to the court. Do you see that? Do you see that?
On the first paragraph, are you looking at?
Yes, at the end of the first paragraph, second sentence from the bottom, three lines up from the bottom of that first paragraph.
Yes.
Okay. And if you look at the second paragraph, in midway through, it says DIUC will employ Guastella and Associates for rate cases with prior approval of its president. Is that correct?
Yes.
Okay, so I'm correct that pursuant to your management agreement, and we'll talk about that a little later, but you're responsible for managing the utility operations. Is that correct?
Yes.
And in that capacity, then, you're also making the decision to employ Guastella and Associates, which is your company, for rate cases. Is that correct?
I'm anticipating that's what we should happen based on the management agreement, and it's all subject to the approval of the president. And of course, the president hasn't been approving it because so far we've been doing pretty good for the utility and its owners. We've succeeded before the Supreme Court twice. Very rare, because courts never like to superimpose their judgment over that of an expert regulatory agency. In this case, this small company has succeeded in overturning regulatory decisions that are very rare. On every single issue, the courts have remanded the cases, the two appeals, back to the commission without accepting any of the commission's adjustments, essentially accepting the revenue requirements that we requested and the components of the revenue requirements.
But you're being hired by Terry Lee and the New Jersey attorneys to operate the system, and in that capacity of you operating the system, you're also making the decision to hire yourself. You don't see any conflict of interest there?
No. It's part of the management agreement. When we entered into the management agreement, it was a small company, and there was uncertainty as to what complications may happen with respect to the small company. As it turns out, this small company has experienced more problems and succeeded in addressing those problems. I could write a book on small company problems, and I could focus all on Daufuskie Island Utility Company, even aside from the rate case, the 7-year rate case. And we've been successful in providing service to the customers, with the owners not getting any return on investment, no dividends, with the owners putting in hundreds of thousands of dollars for cash flow, and with Guastella Associates accepting an accounts payable from Daufuskie Island Utility, so that the money that would have been on an immediate basis paid to Guastella Associates, we delayed collecting through an accounts payable, because our goal has always been to serve the best interests of the customers.
So let's go to the next paragraph. You say, as we discussed, I have not been fully paid for GA. I'm assuming that's Guastella Associates work dating back to 2008. Do you see that?
Yes.
So why have you not been paid since 2008?
We began to manage the company at the request of the Property Owners Association, by the way, when the issue of whether or not CK Materials, the original purchaser of the company from International Paper, would be approved. The Property Owners Association insisted that Guastella Associates manage the company. We entered in a management agreement, and on July 9th, 2008, we began managing the company. Within a short month or possibly two, we found that Melrose Utility Company, which was a separate company at the time, was responsible for 40% of the costs of the sewage treatment plant, the Hague Point sewage treatment plant. But when we found out that almost immediately, that Melrose Utility Company did not pay its 40% share, Daufuskie Island was already not recovering about 25% of its annual revenue. And that created a shortfall and a problem. So from then on, we were willing to wait, we, Guastella Associates, were willing to wait to get paid, because once again, the primary purpose was to, whatever cash flow Daufuskie Island Utility had was going to be used to provide safe and adequate service to the customers.
Okay. But you talk about in recent years, those payables go up to a range of $1 million. Is that correct?
It's ranged as much. There have been payments over the years for quite a bit of dollars, but despite getting paid for all of the, or at least a large portion of rate case expenses, the case continued. So the rate case expenses kept mounting and mounting and mounting for Guastella Associates and for the attorneys.
Well, and if you look at the bottom of that paragraph, it says that you were going to adjust accounts payable to Guastella and Associates for carrying costs for 2021 monthly balances and going forward at the 1% that is consistent with Guastella and Associates' routine schedule of fees. Do you see that?
Yes, I see that.
So you're charging a 1% for each month that you're carrying this $1 million balance?
1% is being applied to the balances, which, by the way, is not included in the rates that we're asking for now. This is something that the owners are going to have to pay, because while I've been willing for years and years to delay getting paid, it's reached a point where when you get to be $1 million, there's time for the owners to have to recognize that I'm not going to keep not getting paid without having a carrying cost applicable to what they're going to pay me, not what the customers are. None of that is in the rates for the customers in this case.
Well, above that, you see where you say David and Ron refused to accept my proposed increase in the percentage incentive fee to Guastella and Associates?
Yes, that had to do with if the utility was sold.
Okay, and what is that incentive fee?
There was a percentage. In the management agreement, there are percentages in the event that the utility is sold. And there's a formula for that where I wanted to increase those percentages.
So you wanted to increase your incentive in the value of the company if it was sold?
I don't understand what you mean, increase my incentive in the value of the company.
You wanted to increase the incentive fee. So if the company gets sold, then you get paid an incentive fee, correct?
We would be paid a percentage of the proceeds for the sale of the utility, correct?
And so the higher the amount the utility is sold for, the more money you make, correct?
The higher our share of that proceeds would be. None of which, of course, is included in the rates.
All right, let's go to the next email if we can. So this is February 3rd, 2022. Do you see that?
Yes,
And again, you say, I have so much at stake in DIUC that I have been doing my best to keep it a successful utility. Do you see that?
yes.
So when you say you have so much at stake, are you talking about the amount that DIUC owes you? Are you talking about your incentive fee? What are you referring to there when you're talking about the stake in the utility?
I'm referring to the accounts payable by Daufuskie Island Utility to Guastella Associates and accounts receivable by Guastella Associates from Daufuskie Island Utility Company.
And you also say that you could not have done so without your assistance, assuming you're referring to Terry Lee, both in time and funding. Do you see that?
Yes.
So what kind of funding does Terry Lee give to you? Or give to
He didn't give
DIUC?
anything to me. What Terry Lee did was provide hundreds of thousands of dollars worth of cash flow to the utility to keep it running, because the delay in getting the rate increase and the cost that mounted, aside from Guastella Associates rate case expenses, and the attorneys were also incurring rate case expenses, and we weren't going to delay paying the attorneys. So we had to generate cash flow for them for making improvements. So Terry Lee was required to, not required, we asked, and he was willing to provide hundreds of thousands of dollars worth of cash flow so that we could keep serving the customers. In addition, Terry Lee, in order to obtain security bonds, was required to buy CDs from SunTrust Bank, because SunTrust Bank wasn't willing to help when we had to get bonds when we put rates in effect subject to refund. So without Terry Lee's help, I don't know whether the utility would have continued without having more problems in terms of serving the customers. So the whole goal was to serve the customers.
So part of the reason you said that Terry Lee and the attorneys had to make investments was to pay the attorney's fees. Is that correct?
It's all costs. I didn't break it down to just attorney's fees, but certainly we had obligations to pay attorney's fees. I mean, not only was Guastella Associates incurring rate case expenses, the attorneys were as well, and the attorneys were going through a bunch of appeals as well. So,
But you agreed to forego payment of your fees as long as you got a 1% per month interest rate.
no, that's not correct. I was not willing to forego any fees that the utility owes to me. And the sale of the utility is not part of the rate case expenses that we were incurring, and which became an accounts payable to Guastella Associates.
But if
there were a sale, then there would be proceeds. If there's no sale, there's not going to be any proceeds.
If there's a sale, then you would get not only the incentive fee, you would also get the payment of your owed expenses plus that is based in part on the 1% monthly interest rate. Is that correct?
The rate case expenses, without any carrying costs added to it, is what we expect the cost of providing service to the customers will be. The 1% incentive fee, if there's a sale, would come out of the proceeds of the sale of the utility, which is not going to be part of the rates charged to the customers.
Let's go to the next. I think we're on February 17th, 2022 email. Do you see that?
I see it.
And the second paragraph, you ask about a cash infusion of $100,000 for about 2.5 months. Did you get that cash infusion?
We did.
You also say
when you say did we, the Daufuskie Island Utility got the cash.
and fair point. I do not mean you personally or Guastella and Associates. I apologize. I do mean DIUC. You also say Guastella Associates has in the past borrowed short-term loans to provide cash to DIUC. So explain that to me.
The loan that we have with SunTrust, which is now Truist Bank, requires that funding be through them. Daufuskie Island needed cash flow, so what Guastella Associates did was borrow money payable by Guastella Associates, or possibly me personally, and we gave the cash flow from that money to Daufuskie Island Utility so that it could keep operating and serving the customers.
And under what terms did you make that loan to DIUC?
They would pay whatever the cost of that financing would be.
Okay, and you didn't earn any premium or any additional interest rate on top of that?
No.
All right, let's go to the next one, which is April 21, 2022. And there you say Mike had Guastella Associates borrow $50,000 to provide DIUC with needed cash until April billings are collected. Did you see that?
Yes, I see it.
So I want to flip back. Previously, you're here, we're talking April 21. We're talking about collecting April billings, and you say you didn't want to ask for any more cash. So flipping to the previous email where you had asked them for $100,000, was this you needed an additional amount of money, or did the owners not give you the $100,000 you requested, or did you forego that request? Can you explain?
Terry Lee came up with another $150,000, I believe. To cover cash flow needed by the utility.
All right, let's go to June. The next page is June 7th, 2022. Do you see that?
I see it.
So there's some discussion in there about condemnation proceedings. Do you see that?
No. If you want me to read the whole thing,
No,
yes.
no, well, I think you could look at the first full paragraph. It says DIUC has been involved in a condemnation proceeding.
Yes.
Do you see that?
Mhm.
So I think this was before my time at ORS, but it's my understanding that back in 2011, DIUC lost ownership of the property associated with the elevated storage tank through a Beaufort County tax sale. Is that correct?
Yes, there was a tax sale, and an individual, Mr. Sabre, paid, I think, $526.70 for the land that's occupied by Daufuskie Island Utilities facilities.
And because you lost ownership of the property, you felt like you needed to go forward with a condemnation action to get it back. Is that correct?
Well, that was ultimately what was decided. We explored first having the tax sale reversed, but the cost and time of doing that would have been long. And the loan that at the time SunTrust Bank gave us, they wanted us to have title to the land, but they were willing to wait for that to happen. As far as I'm personally concerned, if it weren't for SunTrust, I would let Mr. Sabre keep the land, pay the taxes on it, because the Daufuskie Island Utility Company has the right to have utility facilities on that land, regardless of who owns it. They have a right to access, repair, and replace all those facilities. And Mr. Sabre actually can't even get to the land because you need an easement to get to the land, which he does not have. We have an easement through the Equestrian Center. And even if Mr. Sabre was able to get to the land, he can't get on the land because it's fenced in. So this has been another type of problem that a small company is facing that I don't know of any other small company that's faced it.
Okay, well, if you look down with me, I think it's the third full paragraph. It starts, so far this Sabre matter, now 12 years old, has cost DIUC's customers about $70,000 in legal and consulting fees. Do you see that?
Yes.
Okay, and you make a point to note that those costs are recoverable through water rates. Do you see that?
They're being capitalized as the cost of obtaining land, which is appropriate and consistent with the Uniform System of Accounts. And this whole matter was beyond our control because when the tax sale occurred, they did not send notice to the utility that there was a tax sale. They did not post notice of the tax sale on the utility property. They posted it someplace else. So we were never aware that there was going to be a tax sale. The way we found out about the tax sale was a member of ORS investigating the rate case said, "Do you realize that you don't own the land?" And I did not realize we did not own the land because it was never an issue. So that then initiated our whole process of trying to get back the land. I tried reasoning with Mr. Sabre. We offered him some small amounts, but Mr. Sabre, in his latest deposition, believes that he owns the utility. I don't know why he believes that, but that's what he believes, and that's what he testified to in depositions. So it's a whole complicated issue where it's been established that it was, and I believe it's been established even in one of the appeals to the court, that this was not the fault of the utility. This is something else. As a matter of fact, that was one of the adjustments ORS made in the first case to eliminate the utility facilities, the cost of the utility facilities that are on that land, and the court essentially reversed that, and so did ORS.
Well, I guess my question is a little simpler than that, but in that paragraph, you talk about you've already incurred $70,000 in fees, and you're expecting another $15,000 to $20,000 in fees. So you're estimating that it's going to cost about $90,000 to fight that matter. Is that correct?
Yes.
Okay, but then in the very next paragraph, you say that Sabry has offered to settle it for $10,000 to $15,000.
Yes.
Well, if he's offered to settle it for $10,000 or $15,000, why didn't you jump on that? Why are you agreeing to incur $90,000 in fees?
Because when our offer was, we had an appraisal done where the value of the land was $3,700. However, the appraisal that was done did not take into account that the value of the land has to be adjusted for the removal of the facilities. The removal of the facilities would have been a few $100,000, which Sabry could not do. So in order to file the condemnation, the utility had to post an amount, an appraised amount for the land. So we were willing to file the $3,700 appraised value of the land, hoping that that would resolve the case. The offer of $10,000 to $20,000 has become $200,000. So there's no consistency as what Sabry said he's willing to do, or his attorney said he's willing to do, and what's actually happening in the condemnation case.
Well, but that's not what you say here. I mean, what you say is that he offered to settle it for $10,000 to $15,000, and then you say you don't want to be in a position in a new rate case of justifying to the commission that DIUC paid $10,000 to $15,000 for a parcel of land that had no value to the owner.
That's correct.
So you're really fighting that because you don't want to have to argue that position here, isn't that correct?
Well, we have no choice.
You have no choice, but you also get to recover whatever rate case, whatever expenses you think are associated with that. Isn't that what you're thinking?
Well, I actually believe that's correct. We have to incur the costs that were, through no fault of our own, necessary to acquire a piece of land.
Even though you could have settled it for $10,000 to $15,000.
No, when I talk about what's settled here, this is discussions internally. And the internal discussions were, I believe, discussions that Sabry's attorney had with our attorney. And at the time, if we found out that Sabry's attorney was never paid by Sabry, the appraisals that the attorney had on behalf of Sabry never paid for. So Sabry never paid for anything. So you're looking at emails on a general internal discussion, assuming that all of this is documented and ready to go. And it's just not the case. It's a lot more complicated than the way you're trying to simplify this.
Well, these emails were provided in response to our request for board meeting minutes. So you're telling me that when you're advising Mr. Lee and the New Jersey attorneys, you're not giving them the whole story in emails when you're operating the company for them?
I'm giving them the whole story at the time that we had this information. And when ORS asks for emails and we give them emails, I'm giving them all the information. Well, now, they can analyze it the way they want to analyze it, but if they're going to analyze it, they should get their heads into the whole Sabry story that's taken 7 years for a tax sale for $526 for a man that's never paid anybody anything, not his attorneys, not the appraisals, and who's now looking for $200,000. I mean, it's a complicated case.
But none of that is your fault, is it, Mr. Costello?
Of course it's not our fault, and it's found not to be our fault, and I believe it was found not to be our fault by the courts as well.
Mr. Costello, I'm going to show you 3 documents, if you'll, Madam Chair, if you'll give me just a second. Mr. Guastella, I've handed you 3 copies of documents. Again, these were documents that were produced to us in discovery. If you have a chance to look at those, the first one is a management agreement dated June 2015. Is that
Yes.
correct? And the second one is a management agreement dated December 31, 2018. Is that correct?
Yes,
And the last is December 31st, 2022. Is that correct?
yes.
Could you explain to me what these documents are, Mr. Costello?
This is the management agreement between Guastella Associates and the Daufuskie Island Utility Company and its parent.
Madam Chair, this time I would ask for these documents that I will hand up in just a second be identified as the next composite hearing exhibit, if that pleases the commission.
Mr. Gressel,
No objections.
you want a composite exhibit?
Madam
It's-
Chair, happy with whichever one.
Okay, but they're all management agreements between DUIC and Costello and Associates, just different dates?
Yes, ma'am.
Okay.
There was one in 2015, then there was a second in 2018, and a third in 2021.
Okay.
Certainly happy to break those in.
Now, we'll make them thank you. We'll make them a composite exhibit. The 3 management agreements will be marked for identification as hearing exhibit number 5 and received into the evidence of this case.
Mr. Guastella, first let me ask you, and probably for simplicity purposes, well, I guess let me ask you,
May I get some clarification,
yes,
please?
yes, ma'am.
Where is the date on these agreements?
So the date I'm referring to is actually in the first paragraph. It's really the effective date, essentially.
All right, thank you.
Yes, ma'am. Mr. Guastella, generally speaking, I'm not asking for details. I know there are some things that have changed, but generally speaking, these documents are largely the same. Is that correct?
Yes,
So I'm going to focus on the December 2021 document if I can. So can you pull that one ahead for me?
I have it.
Let me first ask you, is this a document or any of the management agreements? Have you presented any of those to the commission for approval?
I believe these were presented in the last case, and I believe, if I recall correctly, the commission approved the management agreement and the work by Guastella Associates.
Has the 2021 agreement been submitted or approved by the commission?
Not that I'm aware of.
If you could look with me on page 2, and I'm looking at the top third of the page, there's a paragraph 5. Do you see that?
Yes,
And it says, this is basically one of your obligations is to operate the company efficiently and manage its assets in order to minimize the rates charged to the customers, but also to achieve a reasonable profit for the stakeholder so that the company will be able to maintain financial viability and attract capital. Do you see that?
I do.
Okay. And if you can turn with me to I believe it is the 4th page. There is a section entitled Incentive Fee. Do you see that?
Yes,
And basically, the incentive fee is a 2-part incentive fee. Is that correct? You've got one piece is you earn 20% of the total net utility operating income of the utility. Is that right?
yes,
And that's on top of your monthly consulting fees. Is that correct?
that's in addition to the monthly fees, correct.
Okay, so the more income the utility has, the more you earn, correct?
The more the utility would be required to pay me. However, that piece is not in the rates. It's the owners of the utility are gonna have to pay this.
And then there's a second part, which is under B, and that is the incentive fee that results in the event of the sale of the company. Is that correct?
Yes.
And essentially, and you can correct me if I say any of this wrong, but there's an adjusted purchase price of approximately $2 million. And then the incentive fee is 8% of the first $3 million that exceeds the adjusted purchase price, 12% of the next $5 million, and then 15% in excess of $8 million. Do you see that?
I see it.
And that's what's in effect today. Is that correct?
Yes.
So Westell and Associates has a direct interest in the value of the company, does it not?
Well, we don't have an interest in the company in terms of we don't have any ownership of the company at all.
No, but you have a direct financial interest in how much the company is valued at, do you not?
I'm going to value the company based on its market value if in the event we need to do that in the event of a sale. And we would get an incentive fee for whatever the sale price is based on this agreement.
But you've been involved with utility acquisitions, correct?
I have.
And from a financial perspective, what types of things do you look at when considering a utility purchase?
We look at the market value. We do an appraisal of the utility, look at the market value to determine what a fair price would be with a willing buyer, willing seller.
Do you look at the utility's
acting in their own
earnings?
best interest.
Do you look at the utility's earnings?
We look at the three methods of appraisal. One of them is the comparable sales approach, and we never find utilities that are either being condemned or negotiating a sale, having a market value based on comparable sales. They're just not comparable in many respects. The other is we look at a income approach to value. And in the income approach, we look at what the earnings of the utility would be as an investor-owned utility, and then we look at what the earnings would be as a municipal utility.
So the answer is, sorry, go ahead.
We find that the range in values based on the income approach is very significant because the income available on a regulated utility, which becomes a undue stimulus, is limited by original cost rate making. For a municipal utility, they don't have that stimulus, plus they can borrow money at a fraction of what the return on investment is for a small utility. So the range in values on the income approach is so wide that you really can't make in my opinion, a good judgment as to what the value is. That leaves the third method of doing appraisals, and that's reproduction costs, new less depreciation plus going concern value, known as the cost approach. So typically, the market values are determined based on the cost approach, reproduction cost, new less depreciation, plus a going concern value.
But the answer to my question is yes, is it not? You do consider earnings when you're considering a utility purchase.
We consider earnings in the capitalized income approach, but then reject that method of doing appraisals for purposes of condemnation or sale.
Does it not interest you what the established rates are for a utility?
Well, it's interest because it's part of the income approach when we project 10 years worth of operations and the present value of the 10-year operations, so that it's of interest, and we put it together in an appraisal approach because in accordance with the uniform standards of professional appraisal practice, you should take a look at all three methods of appraisal, and then if you want to reject methods of appraisal, you can do that, and then you determine what your estimate of value is based on the best approach. So we look at everything if we're doing an appraisal. And of course, earnings is part of what we're looking at, but if it's rejected, then it's of interest, but of no consequence.
Okay. But the higher the rates, the more earnings, correct?
The higher the rates, the earnings might change simply because of the higher rates, but typically the higher the rates, if given a reasonable return on the full investment, is significant.
Well, Mr. Westell, let me just ask you this. Is it your intention to increase the rates and the value of DIUC so that the DIUC customers will be forced to buy the system for a premium that ultimately will benefit you?
No, our purpose for the rate case is to establish the cost of providing service to the customers.
Thank you, Madam
That's
Chair.
the
I have,
purpose.
I'm sorry, I have no further questions, but he obviously can finish.
Thank you, Mr. Mustian. We've been going about an hour and a half. Let's take we'll come back at 3:25, please. Mr. White, you're welcome to continue to sit there, but you might want to find a more comfortable chair.
Glutton for punishment.
Good afternoon, and we are back in the hearing in docket number 2022-142-WS. It's the rate case application of Daufuskie Island Utility Company Incorporated. Let's take a roll call of commissioners. Virtually, we have Commissioner Irvin in attendance, and present in the hearing room, we have Commissioner Jay Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Cassidy, and Chair Belser. We have just finished with cross-exam from the parties of witness Costello. Commissioners, questions? Commissioner Caston.
Good afternoon, Mr. Costello,
Good afternoon, Commissioner.
and thank you for providing testimony.
Thank you.
I noticed when looking through, I don't know what you call it, your background info, your introduction to Costello and Associates and professional qualification experience. A good many pages there, I might add, too. That usually means a life well lived. But I noticed you managed a 5,500 customer water utility from 87 to 91, I think. Is that correct?
Yes,
And that was just a water utility, correct?
yes,
As a manager, and I think you said you would, I think it was in the intro to GNA, it could have been the other one. You were the manager of the utility. Is that correct? What were your primary duties and functions and responsibilities?
with respect to the 5,500 customer
Yes, sir.
utility.
Yes,
The utility is Country Knolls Waterworks up in New York, and I had been doing their rate work and assisting in other ways. The owner had emphysema and was at a point not capable of really running the utility as president of the company. So he asked if I would essentially become president of the company and start running it for him, which I did. At the time, Mr. White was working for a client in Florida, and I had retained, that utility retained Mr. White to come up and do the day-to-day management. And I was the president of the company while still being its consultant for other matters, similar to what we have here for discuss. So we managed that utility for a number of years.
so it says in the intro, you were the manager, and I think in the professional stuff, it says the president. So those were one and the same, or two separate kind of positions, or?
Basically one and the same. I mean, once you become president of the company and I hire somebody who I knew to do the day-to-day management, at the time, Mr. White was an employee of Country Knolls Waterworks, not a Costello Associates employee. But I was making all the management decisions for the utility.
Okay, so, you know, and I won't ask Mr. White anything now, will later, but that was kind of one of the questions I had too, because I noticed he was there about the same time, and I assumed either you brought him in or he was there and y'all got together, but,
Good assumption, that's exactly what happened.
and, in Mr. White's testimony, he said pretty much, let's see, he managed all the utilities, regulatory issues, accounting, and operations activities on a day-to-day basis. In essence, it sounds like he really did everything. I need to quit looking at you. I wish you would go over there.
But I like this uncomfortable seat.
Is that a fair assessment? I mean, that he managed the day-to-day affairs, as you said, doing
Yes.
the regulatory, accounting, and operations activities?
Yes, and he reported to me.
On page 2 of 18 of that introduction to Costello and Associates, you know that your client base has included hundreds of small water utilities, water and wastewater utilities. And I hand wrote this, I probably need to look at it. Obtaining rate increases that will achieve the highest possible profit and ultimate market value. Did I read that correct?
I believe you did. I don't know exactly where you are, but it sounds like
I
something I
gotta
would
find
say.
it too. Oh, it's the second to the last paragraph, last sentence or so.
Okay.
Record keeping procedures, and basically what you did for those utilities, what you do. And not a trick question, it's just the way I think, is GA's role, or your role in GA, to achieve the highest possible profit and ultimate market value to DIUC. Is that your primary role and function, or
Yes.
GA's primary role?
Yes, and when I say highest possible profit, the profit that's going to enable them to maintain financial viability and attract capital.
And this, I guess, management agreement to just handed to me. I really hadn't looked at it. But I was going to ask, does DIUC, and I guess it would be DIUC, or do they have any written mission, vision, value, goal statements related to providing safe, reliable, least cost water and wastewater services to the customer?
I believe when I discuss on page 1 the company goals of the management agreement, either one of the management agreements basically says the same thing.
So that is in, and I'm trying to understand all the associations. You manage, are you the manager for DIUC?
Yes, Guastella Associates is the manager of DIUC, and I'm president of Guastella Associates, and I and my staff undertake all the management of the Daufuskie Island utility.
So as far as the day-to-day affairs running the utility, is that you, Mr. White, and,
Michael Guastella.
well, I didn't
And-
see Michael's name,
and
but I'll
Carrie
take that one too.
Monteri,
And
all-
Carrie, yeah. Okay. So you guys run the day-to-day affairs of DIUC?
Yes, we supervise the operators. We keep the books and records. We do all the billing, accounting, and collecting. We comply with DHEC and are in compliance with DHEC with everything. We file reports, annual reports to the commission, reports to DHEC. We basically undertake the full management of the utility.
Is that on-site or is that off-site?
Part of both. We do on-site work when we go up, and it's mostly Michael Guastella, who's vice president of Guastella Associates. He'll spend time fairly frequently with the operators on the island. For example, when there was a hurricane, Mike went up and made sure that we were prepared for hurricane situations in previous years and now. He works with the operators to see what capital needs they have. He informs the operators what's a capital cost and what's an expense cost. finds out what they're doing, how they're doing it. He hires additional people. We recently hired an additional staff member because we lost one. So he takes care of all that day-to-day information. He also makes sure that all the bills are being paid, that the utility receives, manages the cash flow. Carrie Molteri is an accountant as well as administrator, rate analyst. She keeps the books and records consistent with the NARIC system of accounts. And like I said, we do all the billing and accounting and work with the billing companies to make sure all the bills are out. So we go from beginning to end in managing the utility.
About what percentage of time does Michael spend there versus wherever
At the facility, I would guess, but probably 10 to 20% of the time. Doesn't require all that much. And he's daily in contact with the operators. I mean, nothing happens at that utility that Michael's not aware of on a day-to-day basis. The first person that the operators call is Mike Guastella.
Is DIUC the only utility that you guys, I guess that would be you, Michael, Mr. White, and Carrie, operate?
Yeah, the operators do the operation. We manage that operation. We also manage Kiowa River Utilities. It's a wastewater company in South Carolina. So we also manage them pretty much to the same extent. There's a separate operating company that does Kiowa River Utility. So we don't have to supervise their operators. They're on a contract basis for the operation of Kiowa River Utilities. But we do all the books and the records and the billing and accounting and reports to the various agencies. So we do not have the function of supervising the operators because they're an operating management company.
I want to make sure I understood it. And you may have given a number, but how many, I guess, similar utilities does GA manage?
Those are the only two in South Carolina that we manage. We used to manage Country Knolls, but they were sold years ago.
Well, they don't have,
But,
go ahead.
but with small companies, when they retain Guastella Associates to help them with rates, and particularly most of them are developer-related utilities, the developers were great at real estate development, not great at understanding operating utilities. So we have, for those we get that are brand new development company creating utilities, I'm able to structure their utility operation from start. Most of them, however, most of the clients I've had, and it's probably been 500, 600, I find that they make the same mistakes. They don't know regulation. Regulation is new to them. They certainly don't understand the rate setting methodology and principles. So when we get into, or how to keep books, because their accountants keep books with a mindset of tax accounting as opposed to a mindset of utility accounting. So we essentially provide a lot of management information almost to every small company client that I've had.
Well, what I'm asking, and maybe you've answered and I've just missed it, not just in South Carolina, I'm talking about the folks that are listed that we have here. How many other utilities do these same folks manage, whether in South Carolina, New Jersey, wherever they are? I mean, are those the only two companies that you have similar arrangements with, or there are multiple?
No, those are the only two where I have specific management agreements.
So those two companies, for those 4 employees, pretty much their 100% of their time and salary is spent on those two companies.
Correct.
I also noticed on page 6 of 18 of your professional qualifications, you're vice chair of staff committee of NARUC. It says the activity included the preparation of the model record-keeping manual for small water companies. And I must be honest, because I'm kind of new to NARUC and all that stuff, I didn't know that they had one of those, but it's good to know that they
The
have
manual
that.
was published by NARIC, and one of the things we found was small companies were not familiar with the NARIC system of accounts. Many of them are not required to keep records in accordance with NARIC system of accounts. However, we prepared a manual so that the small companies could start to keep their books and distinguishing what was real estate costs from utility costs, both in terms of the capital investment and the operating costs. So, and this goes back quite a few years. I don't remember how far back, but pretty far back. And that came out of when the NARIC Water Rate School was first getting started. We realized that there needed to be some teaching tool, but we also realized that there should be something that small companies could go to see how to keep their books and records as small companies, not something complicated, but you know, the difference between capital assets and expenses and how to prepare for analyzing their costs the way a regulator would analyze their costs if they ever went in for a rate proceeding.
Well, as I was thinking about that and as I was reading all your information, first thought that came to my mind is, well, let me just ask the question. Does DIUC have exceptional record keeping?
For a small company, it's the best there is. And I've had 600 small companies rate filings because I and Gary and Mike, we know how to keep books and records consistent with what's required of regulated utilities. So I don't think you're gonna find other small companies that are keeping the books and records as consistent with NARIC as the Daufuskie Utility Company.
So you're saying best that you're familiar with or the best there is?
Well, I'm familiar with 600, so I'm gonna say the best there is. It's hard to be humble and be a consultant. So I'm gonna say it's the best there is, and if anybody could find any better, I'm willing to take a look at it.
I don't think I'll be able to answer that, but there might be some that would argue with that, but
I'm sure they
I
can
don't
be.
kind of backpedaling just a little bit. Who is the operator of record for DIUC?
We have a staff of operators. So the chief operator is one of the people who has licenses. I think one or two of the people have licenses. Eric is the chief operator.
Is it Johansson? Johan? Oh, Eric, who is Eric?
Johansson. Eric Johansson.
Yeah, Johansson, Eric Johansson, I'm sorry.
Yeah, I'm sorry, you can't collaborate on responses. Thank you.
It's okay. That's all
Eric
right.
Johansson.
I have trouble remembering my
There was a
grandchildren's
Bill
names.
Donaldson also, but he passed away this past year.
Do you have an idea, I mean, how many hours a day you personally spend specifically on DIUC?
You know, Commissioner, it'd be so hard over the past 7 years because I spend many hours a day on DIUC. Most of it has been in connection with all the rate case and the proceedings of DIUC, but I also spend time with the books and records, supervising what's going on with the operations. I'm the one that Mike will report to with any kind of problems that are active. We have customer complaints that occur, and I get involved in those. So I don't keep my time for how much time I'm working on supervising the management as opposed to all the other activities we've had over the past, since 2008. In the beginning, it was a lot of time because we had to take poor records of the previous owners of the utility. International paper was Hague Point. Melrose was we didn't have Melrose until March of 2010. And by the time Melrose was merged into the IUC, we had to really scramble to get information. And we got some from annual reports. We also had a bunch from the trustee, who I think was getting information from the bankrupt people. But essentially, Melrose disappeared. You couldn't find them, you couldn't call them, there was nothing happening. So we had to actually start to operate Melrose when they went bankrupt, because otherwise none of those customers would be getting service. We didn't charge them for that, but we just felt that since we were on the island with operators that could give Melrose customers continue their service, we did operate their system in terms of operations. And then when we acquired the system, then we began, keeping books and records and managing them the same way we managed Daufuskie. And they were merged into Daufuskie, so it became one utility on the island.
So if I understood you correctly, you don't keep up with your time, or you don't track the time that you spend on
I
DIUC
keep
specifically?
detailed time on proceedings, rate proceedings, and any other formal proceedings. I don't keep detailed time on management because I don't only do work for the Daufuskie Island Utility Company or only manage the utility. I have other clients as well. So I keep specific time on other clients, not specifically time that I need for management. Sometimes the time I need for management is a matter of 10 or 15 minutes. Sometimes it's a matter of hours because we've got a problem that has to be addressed and unique circumstances that are unusual. And Daufuskie has a lot of unusual circumstances.
So,
My personal time is what I'm referring to.
and again, I've not gone through this agreement, and not really sure exactly how it would relate, but is your I guess salary or reimbursement or funding, is it just based on in other words, what I'm more familiar with is whether it's a administration contract or whatever it is, that there's some idea of time, and you pay for time, and that generally is tracked and generally submitted and generally verified and this kind of stuff. How are you reimbursed?
The management fee is based on a flat fee per month. So we charge a flat fee. It's an annual fee, but it's a flat fee per month that's charged for management work. I might add, if it's at all enlightening, in the last case, we put together a comparison of the Daufuskie Island Utilities rates, which essentially reflect costs with other municipal utilities in South Carolina. When we convert those utilities to an investor-owned utility, the Daufuskie Island's costs were less than the average of those costs, even though Daufuskie's costs reflect not having vehicle access to the island. Everything is by boat. So in terms of, if we did just a general cost comparison of what it takes, including our management fees, to operate Daufuskie, we seem to be doing as good or not better job than half the municipalities in South Carolina.
Now, I want to make sure I understand that, because I used to be pretty familiar with those numbers too. Go through it slowly with me. What did you compare? What did you look at relative to DIUC? I want to make sure I understand that.
There's an exhibit in docket 2014-346 that I submitted, I believe, in rebuttal. And I present in that exhibit,
Can you talk into this a little bit more?
I'm sorry.
Thank you.
I present a comparison of the rates for Daufuskie Island for its water and sewer operations on a per customer basis, the cost per customer. And then I compared those average bills for Daufuskie customers with the 108.9% increase included at the filing. And I compared those with the then current rates, even if they were in for a rate filing, we didn't include those, but their actual rates at the time on a bill per customer. And, you know, municipalities don't pay income taxes and that kind of thing. So when we adjusted and convert the municipal customers into the equivalent regulated utility, Daufuskie Island was lower than the average in terms of the bill per customer, which is a reflection of, you don't set rates based on comparisons, but an indication that we were managing and operating Daufuskie Island utility even after a 108.9% increase at cost to the customers that were favorable to other utilities in South Carolina.
So your management fee is a flat fee of X number of dollars. And how much is that?
I believe now it's approaching 200,000 a year.
And how much is that a month? I can't do the math.
About,
I'll figure.
about 18,000 a month, I believe.
Okay. And whether you spend 1 hour a month or 120 hours a month, it's $18,000 a month.
Yes,
Okay.
and obviously there's a lot more time spent by Michael Guastella, Carrie Multari, and Gary White, because, we get into all of the accounting and billing and collecting and supervising employees and responding to customer complaints and complying with DHEC and preparing reports both to the commission and comparing CCR's, customer confidence reports that go to the customers, and we mail them to each customer. So there's lots of time spent. I don't know if this will be helpful, but Daufuskie Island was at a point of being in default on the original debt for the original owners, and we were able to negotiate with the bank, who had already filed for a default action against the utility, and convince them that we were going to manage the utility and get appropriate rate relief. We saved the utility customers about $400,000 in property taxes. It had never been billed, and when it did bill, they billed us for 4 or 5 years, and we were able to negotiate with Beaufort County, and they adjusted 2 years' worth of taxes, and they spread the balance remaining, which was about over 600,000, over an 8-year period without interest. When our lagoon liner failed, we were able to take the earth underneath the failed lagoon liner and work out an arrangement with the Daufuskie Island Fire Department, who was building a heliport. So we saved Daufuskie Island Utility Company over $200,000 that it would otherwise have cost us to haul the fill off the island. And we saved the fire department probably another $250,000 because they didn't have to go off the island to get fill. So we've done a lot of accomplishments to save the customers money in our operation and management of the utility.
Do Carrie, Michael, and Mr. White, do they track their time in hours?
Only for formal proceedings, I believe. Otherwise, they're spending it for the most part.
So, I'm sorry.
Otherwise, they're spending it on management, but whenever there's a formal proceeding, or if we're working, if mostly Gary and I are working on other clients, then we keep track of our time for billing those other clients.
So the 18,000 a month management fee, that's your time, Mr. White's time, Carrie's time, and Michael's time,
Yes,
all lumped together. And whether any of you work 1 hour or a bunch of hours,
or 100
that's
hours, that's what the fee's gonna be.
okay. And I think in one of either the introduction or maybe the history, it talked about CK Materials, I think, acquiring the utility from, I think, International Paper.
International Paper had a subsidiary, Hague Point Inc., which was International Paper's development subsidiary that developed their section of Daufuskie Island. CK Materials LLC was the one who acquired at the time it was Hague Point Utility Company. At the time of its acquisition, the Homeowners Association didn't want the name to be Hague Point Utility Company, so the name was changed to Daufuskie Island Utility Company. And CK Materials then, when we went to go for financing, which required me going to 4 different banks before we could get financing, took over 2 years, with the help of Mr. Lee, the president of the company. CK Materials was a construction company, and during the time when the economy crashed a little bit and there was little construction, they had problems meeting their bills, and I think there was some actions against them. I don't know the details of it, but when we went to financing, the banks insisted that we no longer have CK Materials as the owner. So we had to form the Daufuskie Island Holding Company, which is an LLC, at the insistence of banks that we no longer have CK Materials. So that whole arrangement for financing was very complicated.
I believe you.
Every problem that a small company has had, and I've been involved with NARIC Water Committee for years, 40 years, trying to solve problems for small water companies. As I said before, I could probably write a book on the problems of small companies and point to Daufuskie Island as having those problems.
So again, I'm going to try to understand this a little bit. CK Materials LLC was a construction company that I guess wasn't doing a lot of construction at the time, and
yes,
I
I
guess
believe one of the construction activities was installing pipe, water and wastewater mains. It had a location on Daufuskie Island, and the principal owner of CK Materials had a place on Daufuskie Island and he thought it would be a good idea to acquire the utility. He asked International Paper, and International Paper, who I had filed on behalf of Hague Point Utility Company, said, why don't you use Guastella Associates, who worked for us to get us a rate increase, to help you acquire the utility. So I helped them acquire the utility, and after I helped them acquire the utility, his name was Jamie Karavinchak of CK Materials, said, you know, we install stuff, but we don't know how to run a company. Would we do that for them? And then in our management proposal for the acquisition, the Property Owners Association, to settle whether or not they should acquire the system, required Guastella Associates to manage. And I think it was, at the time I had another company, G2 Utility Management Company, which was the same as Guastella Associates. And we began managing the utility as part of the agreement for the sale from International Paper's Hague Point Company to CK Materials.
And CK Materials hired GA or Costello and Associates to pretty much do what they're doing now for them, for the utility.
At the time, they hired me to do the management. I sent them the management agreement, and you're looking at the end results of the management agreement. And then CK Materials became out of the picture, and it was taken over by Daufuskie Island Holding Company. So right now, Daufuskie Island Utility Company, the sole stockholder, 100% of the stock, is held by Daufuskie Island Holding Company, an LLC, and the LLC members are the president of the company, Terry Lee, Ronald Shumanowitz, and David Hutt.
Okay. So with Costello and Associates, it's an $18,000 a month fee, which I guess the management fee.
Yes.
And what else is in addition to that? Is it just rate cases or rate preparation cases? That is there like a different fee structure for
Any form
that?
of proceeding that would not be part of the management duties that are spelled out in the management agreement. In other words, if we have to enter into proceedings, cases, the condemnation case with Sabre is one where we bill separately, not part of the management agreement. The rate case is, of course, a separate billing under the proceedings for the rate case. So far, I don't recall if there were any other separate proceedings aside from the ones I just mentioned.
And do you guys track that time, keep up with?
Yes, in detail.
And you personally, you're only involved with Costello and Associates. You're not part of whatever the holding company was.
No, Guastella, I'm only involved in Guastella Associates. Guastella Associates is not affiliated with the Daufuskie Island Utility Company or the Daufuskie Island Holding Company. We have no equity interest or stock ownership at all. Every compensation that we're going to get is part of the management agreement.
I'm going to have to be honest with you. I really got a boatload of questions here that I really want to go through for my edification and everything else. So I'm going to go through them as fast as I can. You take as long as you need to answer, but don't feel like you got to take any longer than you need.
Okay.
How many total customers, water and sewer, does DIUC serve on Daufuskie? I saw numbers in the information, but a little confusing. I wanted to make sure I understood.
There were about 1,400 customers in total.
Okay.
Those customers take domestic water for basically indoor use, but they also have a separate meter for irrigation use. It's not a separate customer, but just as if you used a hose to irrigate your lawn, you get one bill. We have a separate meter so that we could charge a separate rate for irrigation purposes, but it's just one water customer. The wastewater customers are also water customers, so it's just one customer. It's not a separate customer. So there are 1,400 roughly customers that take water and sewer service and are charged separately for the different types of service. There are not 3,000 customers.
Gotcha.
There's 1,400 customers.
And actually, that was a few questions down, but I'll go ahead and ask it now because you touched on it. Do all of the customers have a separate irrigation meter, or just those that wanted a separate irrigation meter?
Only those that wanted a separate irrigation meter. And there are no customers with irrigation meters that are not also water use
Right.
customers.
Is your irrigation water charged a different rate than,
Yes.
is that reclaimed water? Or is
No,
it well
no,
water,
that's potable water.
potable water? Are there any sewer-only customers by any chance?
No, I believe all the sewer customers are also water customers. Well, I
What it-
probably should say all of the customers taking sewer service are the customers taking water service.
Water customers. Be hard to produce that without it, wouldn't it? What is DIUC's average day water demand, do you know?
Good question. I don't know what their average, in total what their average, and I don't recall off the top of my head.
So do you know the peak demand by any chance, peak day?
Well, the system is designed to provide service to the connected customers as well as the availability customers. So the demands in relation to the capacities of the wells is still relatively small, or there are only about 500 or so connected customers. So there's plenty of water left in our water permits.
Well, you jumped ahead, but that's where I was heading.
Excuse me.
You jumped ahead, but that's where I was heading because,
Okay.
and I understand that. What is the permitted capacity of the wells?
I believe it's 75 million gallons.
75 million gallons
A year.
a year? Oh, okay. So, few 100,000. I can't do that math that quick.
And I
I'll
think
figure
that-
the average
and
day
If my
on it.
memory serves me correctly, that's 75 million gallons for the Hague Point system before we acquired Melrose, and then Melrose has probably another 25. And I'm subject to check, I could provide that information specifically for you.
How many wells are there?
7.
7? With a firm pumping capacity of, you think, around 75 to 100 million.
But the 75 million is an annual
Right.
level of permitted water to take from the ground. So,
I gotta know. And is subject to check again, as you said, is that 75 million for the combination of those 7 wells? Or did I hear you say you think 75 million and 25 million for one over here?
I think the 75 million is what can be permitted to take. I don't recall off the top of my head what the capacity of the wells would be to produce water and deliver to the system. They're not producing 75 million gallons a year. You know, they're producing whatever the actual demands on the system are. And there's, to give you a sense of it, there's 500 connected customers, but about 800 availability customers. Those availability customers can connect anytime and get water because we have the capacity to serve those availability customers. But at this stage of the game, there's only half of the demand, that's the potential demand on the system. So we seem to be a long way from having to expand our water permitted capacity.
Well, I could have rushed through the math and it might not be right. In any event, what I was trying to figure, what is the average day? What's the peak day? What's the per capita day? And if I did the math right, which I well may have, it just doesn't seem right. It's about 20,000, 21,000 gallons a day and about 14, 15 gallons per capita a day. But I don't need to go there.
You know, I might, I'll try quickly to look at the rate filing because I think we have a billing analysis that will show us, I don't have a calculator with me. Do you have may I ask Gary White if he has a calculator? 'Cause
Yes, sir,
maybe we
you
could
can
do
get a calculator if you want one, but
No, tell me what kind this is. Give me this. This is not a HP.
If I hesitate to interrupt you while you're calculating, but it's okay if you don't have it. Is it going to be much longer, you think?
It's about, they use, if I'm correct here, about 55,000 gallons a year, the average residential customer. Just
55?
residential, then we have commercial customers and others, but the average residential customers uses about 55,000 gallons a year, not counting irrigation.
You're talking about each individual.
Each individual customer for
So-
domestic indoor use is about 55,000 gallons a year. Plus then there's irrigation customers that use, or irrigation use that adds to that,
So a little less than 6,000 gallons a month.
yes.
And what I was trying to get a grip on, and again, I apologize for really, I guess, having you do all that. But what was trying to understand, because the information that at least I saw that was in here, I think looked more like a DHEC sanitary survey, not like the permitted amounts, like the wastewater, what are the wastewater limits, and what's the withdrawal permit, maximum withdrawal permit for DHEC. And really just trying to get a better understanding of, okay, where are things now? How close are you to the permitted capacity? What's water quality and that sort of thing. That was what I was attempting to do.
Okay, we're not close, but, what's in the rates is what the actual consumption per customer is for water, irrigation, residential, commercial. So we know what their actual consumption is, so we know what their actual bills are under existing rates. And then we're able to determine what their bills would be under proposed rates, knowing how many customers use per quarter and then per year, the amount of water that they actually use. So the rate filing is based on actual consumption. And to the extent that I'm pretty sure we're far from our permitted capacity. I think if we start to approach 80% of our permitted capacity, I think DHEC then would ask us to look into the possibility of expanding our sources of supply.
You're required to do a preliminary engineering report.
Yes.
Trust me on that one.
Yes, I do.
So a little less than 6,000 gallons a month, that is for those currently using water, but not including any demand from those that have vacant lot, correct?
Yes, that's correct. And that's excluding the water they use for watering their lawns, irrigation water.
Excludes that?
It excludes that. There's additional amounts of water being used for irrigation purposes.
Do you know what that is?
Yeah, so, did I check?
Oh, goodness. I don't mean to send you down a rabbit hole, so. It's getting there. Trust me.
I got this guy. That includes commercial up there. What did you? Oh, where's the irrigation? 29, 94. And then on an annual basis, the irrigation portion of the customer's bill is about 117,000 gallons. So they use a lot more for irrigation than they do for domestic use.
And that's per customer.
On a per customer basis, that has a separate irrigation meter. Not all customers have a separate irrigation meter.
You know about how many?
About 250 customers have residential customers have irrigation, or all customers have irrigation meters
So is that 117,000 gallons
a year.
for all 200?
Each account,
Did you say about 250 or 200? I'm sorry.
about 250.
So it's averaging about 6,000 gallons a month for the existing customers who are using water. Then you have the availability the customers that aren't using any water because it's standby, and about 250 irrigation meters that use on average about 117,000 gallons a month, which is that a little over 10, a little less than 10,000 gallons a month.
Commissioner, would it be acceptable if we send you a late filed exhibit showing the average
No.
demands?
What I'm interested in, the only thing I'm interested in, is absent any information that I've not seen, just kind of wanted to see if, as a utility, whoever's in charge, and I'm assuming that's you, is, keeps up with that information, has that information, and looks at those total capacity numbers versus, what would be required or may be required. I understand what you're saying, that you got 600 or so that are empty lots. And as is now, you feel there's adequate supply and, I guess, distribution. I just simply wanted to know the numbers.
Commissioner, if my memory serves me correctly, we have permitted capacity of about 75 million for the Hague Point system. And I think they're now using on an annual basis about 35 million, so we're a long way from reaching the permitted capacity.
Okay. DIUC customer, Mr. Jeff Garwood. He expressed serious concerns about the way DIUC is both managing water quality and quantity in operations of its utility facilities. I think I heard you say something about a consumer confidence report. Does DIUC provide its customers consumer confidence reports or CCRs?
Yes, we do. We're required to notify the customers that we have one and it's available, but we do more than that. For those customers that we have emails for, we send them a copy of the CCR by email. And for those customers we don't have email addresses for, we send them hard copies directly to their addresses. So every customer is getting a copy of our CCR.
In like a billing insert, or when you send out a bill, or do you do it separately, or how do you do that?
Good question. I don't remember.
But you send it out.
We send it out. And we're in compliance with DHEC in every respect.
Mr. Garwood states DIUC is unwilling or unable to provide current or historic patterns of water quality and provide current or historic water usage figures. Is this true?
We provide anything customers have. If they have a question and they send in a question to the utility responds. We keep track of every call that the utility gets from a customer, and we keep track of the responses we send to every customer. So any customer asking for any specific information, whether it's rates, service, outages, or anything else, we keep track of, and we file that a report showing when the customer complained and when we responded to the complaint. So if he wanted any information, readily able to get it to him.
Answers another question. DIUC does keep track of customer complaints, responses, and follow-up and such as that, correct?
Yes.
Because one of them, I can't remember who, maybe more than one, that was one of the particular things they complained about, that they couldn't get anyone to respond. Is there on site or a number that a customer can call that is operated or maintained that, first of all, is there a 24-hour number?
Yes, we have on our bills that's sent to the customers, a telephone number at the bottom for any emergency call the customer has. And I think we also have the number to call ORS if they'd rather call ORS. And we have on our website the telephone numbers to call. So the customers have access to the telephone numbers that would reach the utility on emergency or just to call to complain. And they also have access to ORS as well, I believe.
So during regular hours, there is someone that answers the phone and responds to customers?
I think there's also the emergency number that would reach probably an operator. But yeah, there's an emergency number, I believe it's for a 24-hour day call.
So I don't want to attribute something to Mr. Garwood that wasn't his, but I think it was what he was saying. That was an issue, either not getting a response or but you say you guys track that, and are you aware of customer complaints not responded to, or?
For our perspective, we respond to every customer complaint and we keep track of it. I don't know if any didn't reach us or wrong numbers were called or there's a slip up someplace, but as far as we know, every call that we receive, we record. And sometimes it's responded to on the spot, and sometimes we'll investigate it, send an operator out to see if they have a specific problem at their location. And then we get back, if it's a billing question, we explain the billing, and we look into their bills and let them know what they owe, what they don't owe, what they paid, what they haven't paid. So we respond to every call that comes into the office.
I'm backtracking a little bit, but I meant to ask this earlier. Do you know what the percentage of unaccounted for or unbilled water is in the system?
I believe it's very low, but we have to take into account that we've got less than half the customers using water. So if you look at unaccounted for water, that normally occurs for every utility throughout a system where there's a service connection, where there are no customers. That loss, that unaccounted for loss, when measured against only customers that are using water, distorts what a normal unaccounted for water would be. So,
Wait a minute, we'll make sure I follow that. Let's go, excuse me, go ahead and finish.
I don't think, we haven't recognized any problems with unaccounted for water. Anytime there's any kind of a leak, it's found right away and it's repaired. Now, there's normal causes of unaccounted for water, even just in meters. The meters don't record every drop of water that goes through the meters. There are different flows that water are used, and at low flows of less than a gallon, there's the meter is recording less water than is actually being produced to the customers. And if you get a high flow for a meter, the meter is recording less water than is actually provided to the customers. So there's a normal, what I call meter slippage, unaccounted for, that can't be avoided by any utility, large or small. And then there's typically some loss if there's a leak in the system or a hydrant was used without our knowledge. So it's, when you take all of the unaccounted for water, the way you determine the percentage of unaccounted for water is to measure it against the consumption of water that's billed. But if we have 800 customers that are availability customers that don't use water, that distribution system might have unaccount losses that are typical for any utility. But when you measure those losses included in the total losses, it distorts what the unaccounted for level percentage is.
That's a lot to consume. Does DIUC track unbilled and or unaccounted for water such as, as far as meters, I don't know what meters you use, don't care. Most meters do have a detector check, and if a gazillionth of a gallon goes through there, you know it. I'm not aware of a distinction between a meter that's being used and one that's in the ground not being used. Unaccounted for water or leakage is leakage. So does DIUC keep track of unbilled, unaccounted for water? What is the percentage? And do you have a program in place to minimize that?
I don't recall any issue with unaccounted for water that our operators who have been there for years would detect. So I can't answer your question off the top of my head.
Well, maybe not, but yours would be the only system in America that I'm aware of that wouldn't have any issues with it. But do you know if it's at least in the AWWA range of 10 to 15% unaccounted for water? Who would know the answer to these questions, this question?
I don't want to be repetitive, but it's difficult because you measure unaccounted for water in gallons in relation to water that's sold. If you've got a system that's in the ground to serve 1,400 customers and you're only serving 500, the consumption of water for the 500 customers is not representative of what the unaccounted for percentage would be. So there would have to be some adjustment or estimated made to see what unaccounted for water would be. Our delivery to the system, however, doesn't detect any significant amounts of unaccounted for water. So I'd have to go back. I just don't keep that at the top of my head, Commissioner.
I'm surprised. And I don't mean that facetiously, I am, because that's a big deal. And that amounts to a lot of money that someone may or may not be paying. And I don't really follow, I don't follow the part about the meter being used and not being used, because you're pumping X amount of water. You're selling X amount of water. The math is the math. It doesn't matter whether it's going through this meter or this meter's off. It's what's going into the system. It's a balance. So what's not there, the difference, it matters. So I'm not trying to be mean or facetious. I'm just very surprised that you don't have that or don't know that, because that can be significant. I would think if you're not doing that, or DUIC is not doing that, no. I think that'd be a very wise thing at a minimum to keep track of, but maybe ORS has information on that. How many full-time staff does DIUC have at Daufuskie?
The operators, there are 4 operators.
They're just operators?
Yes,
Water and wastewater, 2 wastewater, 1, 2 water, or
they do all.
They have license for both, dual license?
Yes.
So who fixes the leaks?
Our staff will fix leaks unless it requires a contractor to really get in and start replacing mains of any significant size, but our operators repair leaks themselves.
How many leaks do you average a day, a month, a week?
I'd have to check, Commissioner.
But you do keep track of that.
Yes.
Do they update maps? Do you have pretty much current maps that tell you where your lines are, what type they are, how old they are and such?
We submitted detailed maps of our water and sewer system with the application.
I saw that. Is that updated when
Yes.
you have a new leak or whatever and you find, oh, that is PVC, and oh, that is,
We have current maps of the water, just all the water mains, and wastewater mains, and location of facilities.
do those four operators also do the routine maintenance?
If it's routine that they're capable of doing, yes. If it requires outside assistance, then we would hire somebody, for example, to replace pumps or do something significant, replace aerators. Then we need to hire outside contractors to do that.
Do you have someone on retainer, or is it just someone on the island you use? Or
We don't have anyone on retainer, but we know people who are thoroughly familiar with the system, have worked for the utility for years, so we're comfortable with people who are familiar with the system and have worked with us before, and are willing to go to the island. There are a number of contractors that are just not willing to go to the island and perform service, too costly for them.
Mr. Costello, I know you're probably tired, but I need for you to speak into that microphone a little
Oh,
bit better.
sorry.
Thank you very much. Appreciate it.
I noticed also on the, I think it was the information that maybe Mr. Mustian or someone provided from the appraisal that you had done, and I don't know if it was the compass thing or what, but I noticed looking at the numbers there, it had something 11,101 linear feet of gravity sewer, which that may be, but does Daufuskie Island have 11,100 feet of gravity sewer?
No, it has much more than that, but what we did was we took a sample by wheeling the mains off the maps. We just wanted to get a representative sample rather than doing an appraisal of the entire system. Would have been much too costly and unnecessary. So we wheeled sections of mains where we knew the exact footage of main, and when we wheeled sections of water main and wastewater main, we had the reproduction costs per foot for those sections, and when we priced those out, we came up with what the current cost would be to replace them, and then through the trended vintage cost study, we were able to trend back what the original cost would have been based on current costs information. And when we did that, we came up with numbers that were so far in excess of the total of all of the mains and facilities in question, including the treatment plant, that it established that what was booked by Melrose Utility Company was far reasonable than we even expected.
So you're saying that Daufuskie Island or DIUC, as far as the lines in the system, there are more than 11,100 linear feet, 101 linear feet of gravity sewer? I saw a lot of force mains.
11,000 foot number, I'm sorry where that came from.
I'm not saying it isn't, I'm just curious. I mean, on the island, that much gravity sewer, but, well, maybe.
Commissioner, I don't recall off the top of my head how many total feet of main.
Well, you understand what I'm saying, though, the difference between gravity sewer and force main?
Yes, the gravity sewer would be more expensive to install than force main, because force main, the wastewater is pumped through the main, so it doesn't have to be different elevations for installing the mains. For gravity mains, the cost per foot to install a gravity main means that you may be starting at 3 feet but then you might have to dig down to 12 feet in order to have the flow by gravity. And then from there, it goes into a lift station, and then the lift station would pick it up, and then you'd have force mains taking it further along the system. So there's a range of cost per feet for gravity and force main.
And they derive those numbers from the maps provided, or do they go in the field and verify the manholes, lift stations?
They came up with a unit price for mains anyplace in the system on Daufuskie Island. And when they came up with a price for mains, and we applied that to only a portion of the mains in the Melrose system, for example, the cost for only a portion of the mains trended back to the original cost, showed that the original cost as booked was much less than what an estimated appraisal would come up with.
Well, what I'm asking is, whatever Compass did they physically go out and measure these, inspect them, look at, the manholes, the equipment?
They physically inspected the system, but we measured the footage of main by going to the maps that we have of the system, and we measured sections of mains.
Well, that's fine. I was just looking at their hourly rate and the hours, and I don't know what they spent, but I think if I did the math right, it was about $4,250. And, maybe maybe it didn't take more than that to do the details.
That's per hour. The total bill was in the neighborhood of $4,000, which is very inexpensive
Right.
to do appraisal work. I mean, if they had to go through and actually appraise everything and go through that process, they would have come up with millions of dollars, and it would cost us $40,000 instead of $4,000 to do that kind of an appraisal.
So how many water and wastewater utilities have they evaluated or done appraisals for, do you know?
I don't know how many. I didn't look into that.
But it's not like evaluating a house or a commercial building as far as the utility itself evaluation, physically going there, understanding it, looking at it, going the evaluation. Do you know if they've done that in the past anywhere, or was this the first time they've done that? I mean, I don't know.
No, when actually they were recommended by the attorneys because they knew they had done that kind of work. And utility appraisals are not like real estate appraisals. Utilities are specialty property. And for specialty property, you don't do comparables. What you do is you estimate what the cost of installing different facilities, mains and lift stations and treatment plants. So they had to have that kind of knowledge and experience to come up with their appraised cost, unit cost for those facilities. And they did, and I spoke to them directly, and they were getting information from other engineering firms to confirm the estimates that they were looking at. They did what's typical of appraisers to do. If I go out and do an appraiser and I wanted to know what a local cost is, I then go to contractors who do that kind of work, under other engineers who do that kind of work, and we come up with a cost in a specific area of the utility being appraised. And that's the kind of thing that they did.
Backpedaling a little bit, Mr. Carwood states that generator fuel tanks that would provide electric to the utility system in the event of an outage have been historically empty. Is that true?
I'm sorry, I didn't hear the.
said, Mr. Garwood, one of the customers, and I'm sorry, this is out of sequence. I don't know why, because it's where I wrote it, I guess. Stated that generator fuel tanks that would provide electricity to the utility system in the event of an outage have been historically empty. Is that true?
No,
Any idea why he would say that?
I
never mind.
haven't a clue as why he would say what he said.
Oh, here it is. This is what I was looking for. The other complaints Mr. Garwood had said. There were customers contacting DIUC with no response. Customers contacting DIUC regarding damaged or leaking or leaky pipes, assets. DIUC either did not respond or suggested pipes and equipment were not those of DIUC, and any damage needed to be dealt with by the customer. And DIUC failure to respond to customer billing questions. Is none of that true either?
That's correct. None of that is true. There was a leak, and the leak was a water line that serves a lift station. So there's a water connection to the hose that enables the Daufuskie Island utility to wash down a lift station. I believe there was a leak at the tap or somewhere in there. It was noticed and it was repaired, and it had absolutely no impact on any customer service whatsoever, not for wastewater and not for water.
There was one other customer, I can't remember her name, she was complaining about a leak that had been going on for a while. It was bubbling up from the ground, but I don't remember what it was. And I know we reached this subject before, and you couldn't remember how many leaks there are you fix a week or a month. But when you,
Commissioner, if I may, if there's any significant leaks, the operators would know and they would let us know. And they would let us know that we have to attend to something. When we don't get that kinds of reports from the operators, it's simply not a problem. Simply not a problem.
well, if you're not real sure what your unbilled or unaccounted for water, how would you really know that? Because some leaks you don't see, because especially in sandy soil.
The operators would know what they're delivering from the system. So they know if there's any increase in the normal delivery to the system. That would be one way of detecting it. The other way is you'd see water gathering someplace because there's a significant leak, and it would show up right away. And we just haven't had operators telling us about any kind of significant issue with that.
And what concerns me, or the reason I'm asking, and I'm not taking a side either way, I'm saying I've had customers, there were customers that provided testimony that said there were, you say there aren't. You're not aware if DIUC is keeping up with unaccounted for water. And in sandy, loamy soil, you may or may not see a leak coming up, but it's, there are no leak-free systems that exist. It's always the matter of how much. And I do think that's something that should be, going forward, needs to be resolved or kept up with or information provided, because that matters. And maybe it is, as you say, there are none. You don't really have any.
I'm not saying there's no leaks, Commissioner, but there's nothing significant happening. If there was anything significant, the operators know how much water they deliver to the system. They keep track of daily delivery of water to the system. And if there's any unusual amount that shouldn't be there, they would know about that.
I can understand that, but again, if you're not keeping up with unaccounted for water, you can have a pinhole that doesn't seem like anything, that at the end of the year is an ungodly amount of water. So while if it's bubbling up, they could tell you, I believe that the utility, every utility should know how much water is going in their system, how much they're selling, and how much they don't know what happened to it. Because ultimately, the customer is paying for every drop of it, every drop. And an efficient, economical utility recognizes that, and all they can, they track the right stuff. They have the metrics to measure to know, am I doing this well or not? Because the customer's only counting on the utility. Do you agree?
Yes.
Madam Chair,
Commissioner Urban?
may I ask Commissioner Caston a question?
Yes, sir, you may.
Commissioner Caston, I know you're reviewing some notes, but I had some follow-up questions I wanted to ask the witness on the issues you raised. Would you yield 10 minutes of your time to allow me to ask those questions before I forget?
I don't know if it's okay with you.
Commissioner Urban, Commissioner Caston yields. Please go ahead.
Thank you. Sir, you had testified earlier that you have 4 operators employed. Is that correct?
I believe that's what I said, yes.
Come closer to the microphone
Yes.
because I'm having difficulty hearing you. Could you provide the names of those 4 operators for us?
Eric Johansson is one. We had, Bill Donaldson, who was an operator that passed away. We have a brand new
I'm
one.
just interested in current operators. You testified that you have 4, and I need those. I'd like to have those names if you could provide them, please.
Yeah.
You don't know who they are?
I know that we have the names of Bill and Kevin and Eric, and the new one, I think his name is Kevin, but I don't know I don't recall their last names. Michael
you
Guastella
testified-
deals with them
Yes.
on a day-to-day basis.
Who does?
Michael Guastella,
Is he planning to testify in this case?
no.
Is he your son?
Yes, he is.
Is he a salaried employee?
He works for Guastella Associates. He doesn't work for the utility directly.
That wasn't my question. Is he a salaried employee of your entity?
Yes, for Guastella Associates.
What is his annual salary?
It varies depending on the level of income we have and cash flow.
Does he have a employment agreement with you?
No,
You said his salary?
yes.
What is his current annual salary?
As I set what he's able to take out of utility based on the cash flow of Guastella Associates.
What is his annual salary?
I don't
this year?
know, it varies. It's approximately about $100,000 a year.
Could you provide us with a late filed exhibit redacting his social security number with the last 4 years of his W-2?
Commissioner, I believe that's proprietary information. I don't want to give out information about Guastella Associates' salaries and payment. We have a management contract with a fixed fee.
Well, that was going to be my next question. How did you arrive at your fixed fee for the utility?
Back in 2008, I estimated what we would require to be the manager of the company. The company would be getting an accountant, an engineer, a rate expert, a consultant with experience. They'd be getting bookkeeping. They'd be getting office space, computers, and equipment. So I estimated what that would be based on my judgment. And I looked at what other utilities were incurring for management costs.
And you came up with $400,000 a year?
No, I came up with an amount at the time was, I forget what it was, maybe 15,000 a month or maybe less, and then it was increased each year by a fixed percentage and growth in customers.
Now, excuse me. It now exceeds $400,000 a year, is that correct?
No, $400,000 a year is what we estimated for the current rate case expense. That has nothing to do with the management of the company.
All right, so let me be clear then. You have a separate contract agreement with the utility for management services. And I want to know how much that is per year.
I believe now it's approximately $200,000 a year.
Why have you not had your current management agreement approved by the South Carolina Public Service Commission?
No particular reason. The commission has been aware of the management agreement ever since the current owners, for the most part, acquired the system. And in each of the cases that we filed since then, they've gotten copies of the management agreement. I believe in DACA 2014, the same question was asked, but the commission recognized that the management agreement was reasonable. I just
Well,
never,
it's changed, but it's changed since 2014. So my question is, why haven't you submitted the most recent agreement for approval?
well, it's here in the record and consider it submitted for approval.
You testified that all 4 of your operators were certified for both water and sewer. Wasn't that your sworn testimony?
No, not all 4. There are only, I think there's 1 now. There used to be 2. There's 1 now and another one about to get his certification.
Did you not tell us earlier that they were all certified for both water and sewer?
No, I don't believe I said that.
Would you please file a late file exhibit attaching their certifications, the 4 operators, their names and certifications, please?
Yes.
Thank you.
We'll hold hearing Exhibit 6 for a late file exhibit with the names and certifications of your operators, Mr. Gastella.
And Mr. Gastella, since your son, Michael, is the manager for this regulated utility, I'm going to ask you again if you would be willing to redact his personal information and file a late filed exhibit showing us the last 4 years of his compensation that you testified about.
For Guastella Associates? I have a problem doing that, Commissioner. That's proprietary. I compete with other consultants. I don't want other consultants to know what I do and don't pay my employees. I have to bid on jobs for other utilities. So, subject
Well,
to
we'll
my
give you
discussion with
confidential-
counsel, I'll
We'll give you
respond.
confidential, treatment. We will not, it would be subject to non-disclosure. So we look forward to receiving that information.
Commissioner,
Yes, ma'am.
I think that the expenses that are charged the utility are reflected through the management agreement and the invoices for the work that from Gastella and Associates. Those are the amounts that are charged to the utility. It might not be Mr. Michael Gastella's whole salary. That his whole salary is not charged to the utility. Am I correct on that, Mr. Gressett?
That is my understanding, Commissioner, that Michael Guastella is an employee of Guastella Associates. Guastella Associates is paid a flat fee for its work for Daufuskie. It's also paid a fee for other work, and Guastella Associates sets Mr. Michael Guastella's salary and pays him.
Commissioner, I respectfully overrule that request for a late filed exhibit. I don't know that it's totally
We'll
relevant.
withdraw it.
Thank you.
I was going to use it for another purpose, but that's okay.
Thank you.
I yield back to Commissioner Caston. Thank you, Commissioner Caston.
Thank you, Commissioner Irvin. Commissioner Caston?
Thank you. I'm backtracking again. Handy Whitman.
Yes.
I can't say I've never heard of it, but I don't know if I have. I just don't recall it. So honestly, I'm not familiar with it at all. But I was trying to I think I kind of understand what it does, but does the Handy Whitman Index take depreciation into consideration of what the value of vintage cost would be if depreciation had been applied? Because, you know, when I kind of looked at that one sheet.
No, it does not, Commissioner. Handy Whitman deals strictly with the original construction cost of utility facilities by various primary plan accounts for utility facilities. And they measure the original cost from year to year and the increases. And if there were decreases, they'd show that. But for year to year, there's typically increases in costs from year to year. They went back to 1912. And each year from 1912, they determine what the next year cost was in relation to the previous year and each year thereafter, so that I can then take an index for the year 2000, compare it to the index for the year 2022, and by dividing one by the other, determine what the cost would have been, applying that to today's cost to come back to what the cost was in 2000. Handy Whitman indexes are used by just about every engineer I know that does appraisal work for certain costs and projects.
It could just be, I'm ignorant about many things, so I'm not going to say much about that, you know. I just don't recall ever using it, working with various engineering companies, me personally, but maybe someone did. And then I guess the question, I think it was with Mr. Mustian, I can't recall, but I think you guys were talking about independent third-party studies, you know, whether that's depreciation or cost of services study, that if I understood that exchange, basically that's part of your contract and you're the one that makes that decision and you hire you, in essence, is kind of what I heard. Is that a fair assessment?
It's close. In the management agreement, in addition to the fixed management fee any work that would be outside the services provided in the fixed management fee, such as proceedings, rate proceedings, or other work that's not typical within the management function, would be subject to approval of the president of the company, performed by Guastella Associates.
And I don't doubt your ability to do these kind of things, but I'm also keenly aware that part of my role also is to weigh and balance things, balance the utilities interest, the customer's interest. Does it seem like it's efficient and economical? And that concerned me a little bit, that how does the customer know they're getting the best cost at the best price? Because there's some pretty big numbers there that I saw. Those were, big. So I can't speak for the other commissioners, but how do we know that this is the most effective, efficient, and economical way to do things if it's never given an opportunity?
The cost allocation study would be part of, and they're looking for it for the next case, would be part of what I could do in the next case, pretty much without any additional cost. We have all the information of what it costs for the operation and the facilities to serve the customers. The independent means that you suspect that I would perform a study, if it's Guastella Associates, that would favor residential or commercial customers or irrigation customers, which has no impact on terms of independence, because no matter who does the study, me or anybody else, the overall revenues are going to be neutral. It's a revenue neutral study. I have no axe to grind whether I or the commission wants to raise residential connected customers more than availability customers, or vice versa. So to suggest that there's some independent necessary, it just doesn't apply to that type of study. In terms of cost, I've performed these costs. I teach how to do these costs. I've done these costs and they've been accepted by other experts who do these costs. I've examined other experts doing cost allocation studies, and I find errors in their costs. So if I were going to pick the best estimate to do a cost allocation study for the Daufuskie Island utility, I would pick me independently and unbiasedly. It's going to be the cheapest way for the customers, and they're going to get a result that's reasonable as could be. And if the commission or our staff thinks that a different rate structure for commercial irrigation or availability customers is warranted, the revenues are going to be neutral, and I would not argue with them. And they would get a detailed study that allocates the cost of plant, the operating expenses, and every component of costs allocated to each of the class of customers.
Mr. Costello, for a moment, I don't want you to think I'm questioning your ability or anything else. But I do recognize that the customers on Daufuskie, they don't have a say. They don't. So it is my job, personally, I can't speak for anyone else, to listen to this stuff, pay attention to this stuff, ask questions about this stuff, because it is my job to kind of balance the interest of the customer, other parties, and the utility.
I understand that, Commissioner. I appreciate that. And I assure you that ORS looks at every penny that we spend, and it would look at every study that we provide. And I think they have a capability of fairly evaluating a cost of service study that would be presented.
Well, if I may don't think I'm mistaken, but I think they did express some concern about some of those things and about the need to have third-party independent consultants. And
Commissioner, they don't provide a reason why they want a third party. I've just explained why it's unnecessary and it doesn't impact the customer classes of customers. I don't know why they want a third party investigation unless it's they just don't want Guastella Associates to do one. That's the only reason I can think of it. I may be mistaken entirely. But calling for I don't know why they want an independent study. There's no cost basis for an independent study, and there's no results basis for an independent study.
then if what you're saying is accurate, which I have no reason to question you, these big numbers that I see, especially related to rate cases, since you have all the information and all the knowledge, and you said even in a cost of service study, it pretty much wouldn't cost anything. I'm just struggling to understand why these big numbers are there if it doesn't cost anything to do a lot of this stuff. Where's the cost coming from? These are huge numbers for 1,400 people to pay.
Exactly. A huge cost that's not the fault of the Daufuskie Island Utility Company. The huge numbers are coming from a failure to establish the cost of providing service in the Commission's first decision. The huge numbers are coming from the need to appeal the first decision. The huge numbers are coming from the failure to establish the cost of providing service in the second decision and the cost of having to appeal that decision. I'm merely looking for the cost of providing service. So the huge numbers have nothing to do with cost allocation studies. They have to do with a small company going through 7.5 years worth of rate case that ultimately wound up allowing the rate increase that we originally filed for. I'm being quite frank and honest with you, Commissioner.
I appreciate that, and I prefer that. I like frank, honest, and candid. And at least from what I'm hearing or reading from ORS and others, and these emails that at first, I'd seen these, maybe they were there and I missed them. I believe there is concern from others that these costs are concerning, and I must be honest with you, and I know you explained that's not the case, but when I read some of the emails too, it almost seemed like, well, I'm 100% sure we're going to get this, but if we don't, we're going to sue them anyway. And maybe that is the case. Maybe that's the way you feel. My only job is to weigh and measure the facts, be honest, look after all parties as equally as possible, and do the just and right thing. That's all I'm interested in. For whatever reason, I don't have a thing to do with the past. Past. I'm interested in right now. ORS has expressed concerns about some things. I think they seem like pretty legitimate concerns, but I don't know. That's what we're trying to get to the bottom of. Like, is it relevant? Does it make sense? But all that said, I'm gonna close with this. This agreement, first I've seen, and earlier you had mentioned how you'd gone through some numbers and did some evaluations and how DIUC ranked pretty good with all utilities, and when you factored in the municipal utilities, which I don't know, maybe it did. But as I understand it, and I can't remember where the information was, which one it was, that currently your rates are the second highest in the state on wastewater and first on water or vice versa. And if this goes into effect, you'll be the highest. Maybe they should be. I don't know. But when I think in terms of this agreement that first time I've seen it and the things highlighted, that I'm assuming, and I don't know if the owners give you a review. I don't know if it's based on this, or I don't know if they check anything on this, and whether you do it or not, you still get the same amount. But it does say, provide safe and adequate water and wastewater service to customers on a continuous basis, respond to customer inquiries quickly, accurately, and courteously. You say you do, you've got at least a few customers here, say you don't. I don't know.
Commissioner,
Yes,
we have dozens of customers who have called in and got responses quickly, compared to the 2 or so that you're saying they didn't. If we got a call or a request from a customer, we keep an exact record of it, and we have dozens of those, and I believe we provided those in response to discovery. I'll have to check that, but
I don't know what the appropriate percentage should be, but I think you said you have about 400 customers that take water or use. I
about
can't-
500 that.
500. And there was 6 or 7 or 8, I don't know, that responded. Now, that's not a big number, but when you look at the relative percentage of the number of customers, it's kind of bigger than anyone so far since I've been here that I've seen. But then again, I may have missed something from a relative percentage. And then when I look at the part here where it says, number 5, operate the company efficiently and manage its assets in order to minimize the rates charged to the customers, but also to achieve a reasonable profit for the stakeholders so the company will be able to maintain financial viability and attract capital. Again, there may be a reason that we haven't discussed or in the past that I don't know. But is it true that currently Daufuskie has the second highest wastewater rates and the highest water rates? And at this passage, you'll be number 1 in both of those. Is that an accurate statement?
I don't know. All I know is I submitted an exhibit that was unrefuted in the last case, showing that when you take the municipal utilities in South Carolina and you convert them to an investor-owned utility, the average cost per bill, per customer, water and sewer combined, was less than the average. I don't know what you're looking at, and I don't refute what you're saying, but this is a utility that's on an island. Everything costs more for this island than any other utility. We have fewer customers, so the cost per customer should be higher simply because of the number of customers that we have. So it's I don't refute what you're looking at and how we compare to other utilities, but the increase that we're looking for was 108.9. It was granted. There were some changes in the cost, but the costs were the costs at the time of your January 18 decision, not you, the commission at the time. Sorry, I went to do arithmetic and
If you need to get that, I can wait.
yes. I went to use my calculator. I forgot to turn it off. I apologize.
No apology necessary.
And the rate increase we're looking for now of 47%. If we didn't have the rate case expenses from the previous case to build into this case, the rate increase would be less than 30%, far less than 30%. So a large portion of this increase is because of the rate case expenses that were incurred to deal with the last case. I'm hoping to avoid that for this case. I started that with my testimony. I want to establish the cost of providing service. I'm not looking to have to go back and rehash similar issues before a court. Last thing I want to do.
You sure did use it a lot in your emails, but maybe it's just kind of where things were at the time, and I understand that. Don't need to debate it. And relative to the customers, I think you got about 500 that take water, and the rest of them are availability. So it seemed like it'd be a great system. You only got 400, 500 people to deal with, but you're selling it to 1,400, and you don't know how you compare to Kiowa Island rate-wise, do you?
I don't recall off the top of my head. I happen to have prepared the rate filing for Kiowa Island several years ago, but I don't recall their numbers. And Kiowa Island doesn't have its own water system. It buys water from John's. We have our own water system, and we have 2 treatment plants. I believe they have 1. So, and they have a lot more customers over which to spread their costs. So I would expect their rate should be lower than ours on a per customer basis, because they don't incur the same level of cost that we do. and they have fewer facilities, and they have more customers over which to spread the costs.
Do you know how many customers they have?
I believe it's between 3,000 and 8,000 that they're dealing with. If I recall, I do a lot of rate cases for a lot of companies, so I believe that's what the level of costs are. And we actually, in the last case, had to deal with our management fees compared to theirs. And I believe our management fees compared favorably to their management fees. In other words, Guastella Associates' management fees for Daufuskie Island Utility Company were less than their management fees for Kiowa Island Utility.
So finally, your level of treatment, what level of treatment? I mean, your wells, you have, I think, 7 wells. What treatment do you provide?
Chlorination,
So it's pumped water with chlorination.
yes.
That's pretty good. And that's enough. You'll be glad to know, to the best of my knowledge, I have no more questions. And I
I
appreciate,
appreciate the questions and the frankness, Commissioner.
and I appreciate your patience. Thank you very much,
Thank you.
Mr. Costello.
Commissioners? Mr. Costello, I'm not trying to hold you up this afternoon, but I do have a few, if you don't mind. Availability fees are included in operating revenues, is that correct?
Yes,
Okay. So the utility is using the collection of the availability fees in day-to-day operations to pay for
Yes.
day-to-day operations?
yes.
Okay. With regard to the rate case expenses on the reparations appeal, that case has not been concluded, is that correct?
Correct, that's before the courts
It's
now.
still pending. Is it your position that should the court deny or affirm the commission's order, deny the appeal basically, that the utility should recover all of those rate case expenses associated with a denied appeal?
Absolutely.
And what's your basis for that, please?
The utility has a responsibility to its owners and essentially to its customers to make sure that the rates that were allowed are producing the cost of providing service. We should not be denied the ability to pursue that kind of inquiry at the courts once the commission denied reparations, because it in effect discourages the utilities from protecting their own interest if it wants to appeal a decision. When we appeal decisions and we come up with rate cases, the rate case expenses are not adjusted if we get less than what we filed for. The rate case expenses are all allowed. The company is incurring costs. The commission recognized that we might go to appeal, and I believe recognizing that we might go to appeal recognizes that we're going to incur costs if we had to go to appeal. Eventually, we did have to go to appeal. Didn't want to, but we had to. So I think it's unfair to the utility and its owners to deny costs of pursuing regulation and adjustments to regulation if the utility believes those adjustments are not covering the cost of providing service.
But if the commission is charged with balancing the interest of the utility and the shareholders versus the interest of the customers, what's the basis for making customers pay for an appeal that is not successful?
Well, you're certainly not giving us more money for appeals that are successful. We were successful twice, we're not getting more money for it.
You wouldn't get
That's-
more, but you would recover your costs.
And that's all we're looking for now, recover the costs of our right to pursue the cost of providing service if we disagree with a regulatory decision.
Okay, even if ultimately the appeal is unsuccessful?
Correct.
Okay. Have you followed that up with looking at any old commission orders of this commission?
No.
Okay. I think this is going to be a question for Mr. White based on his exhibits, but I am I'll just admit, I'm a bit confused. And I want to understand what is included, and this is just a preview, and Mr. White, you're hearing it, and ORS is hearing it, and I think those are our accounting witnesses. But I really want to understand the $699,000 that is carried over from the previous rate case that the company's seeking and ORS has made adjustments. I want to know what that amount is. I go through and I think I understand it, and then I read something else and I'm not so sure. So please know that that's coming tomorrow. And then also the rate case exhibit. I'm gonna want to go over that. Rate case expense exhibit. I want to go over that as well.
Sure.
Mr. Costello, you indicated that the customer base was around 1,400. Is that correct?
Correct.
Okay. Is that counting water customers and irrigation customers and sewer customers separately, even if a water and irrigation customer may be on one account? Because I was having trouble getting to
Yes,
1,400.
we're considering a customer that has different types of services and are charged different rates.
Okay.
So we have a water customer that uses domestic indoor, for most part, water, and then they water their lawns. Most utilities don't have a separate irrigation rate for watering lawns. It's just part of their water bill. But we have a separate irrigation rate to recognize the higher cost of providing irrigation service. So that's not a separate customer, that's one customer. We also have wastewater customers that are the same as the water customers. One customer receiving different types of service and paying different types of rates. So the total customers we have are 1,400. We don't have 3,000 customers.
Well, are the customers paying availability fees in that? Because I was even looking at the
Yes,
application.
I'm counting the availability customers as being
Maybe
1,400.
that might have been what I was missing and what I was trying to figure that out. Okay. Okay. Thank you. Commissioner Powers, Vice Chair Powers.
Thank you, Madam Chair. And I only have just a few questions. In the email, something came up about a Sabri case that was set for September 13th. Did that case go to court?
No, at the time, I think it was a week before, a few days before the case, Mr. Sabri submitted a doctor's note and said he was too sick to show up. So it was rescheduled for a month later. And I was in the hospital having a kidney stone removed, so I couldn't show up.
Well, that's one way to get out of it.
I know. So the case is now set for February 13th, I believe.
Okay, thank you for that answer. The other thing that I really haven't had a chance to look at the contract, and we'll do so overnight. But in your rebuttal testimony, I don't remember the exact statement, but it was about this excess tax money, that refund in that excess tax money was improper retroactive rate making.
Yes.
That was pretty much your statement, wasn't it?
Yes.
Okay. But this appeal that you have, aren't you asking the court to retroactive rate make in what you asking for?
No, completely different. What we're asking for is the commission to correct the 88.5% increase that it allowed in January of 18, which is appealed. And the court in the second remand decision did not accept the adjustments for the two issues that were raised in that second remand decision by the commission. By rejecting it, they did not accept the 88.5% increase. Part of it was Guastella Associates and the other part was the utility plant and service. So we still have a pending case with respect to that 88.5% increase, pending in the name of reparations. That's not retroactive rate making. This case is still open and still pending. Retroactive rate making only happens after a final decision, and we're waiting for the courts to give us that final decision on the 88.5% increase.
Okay. Is there any form of retroactive rate making that's proper?
This is not retroactive rate making. Retroactive rate making that says after a final decision, in the next rate case, the company asks for to make up for past losses. That's prohibitive retroactive rate making. And that is specifically the only type of retroactive rate making that is prohibited. Correcting a decision that's still pending a court review is not retroactive rate making. There's a pending decision, and for example, on the tax issue, the rate increase that was given March 1, 2021 became a final rate. We are not asking in this rate filing to make up for past losses. We only earned an average of 3% instead of the 9.31% return on equity. We cannot come back to the commission and say, you gave us 9.31, we only earned 3. Therefore, you have to make up for that shortfall. We can't do that. That's retroactive rate making. Correcting a decision that's still pending with respect to that 88.5% increase is not retroactive rate making. Reparations is a completely different term than retroactive rate making. Reparations in this case just means correct the decision. We asked the court to correct the 88.5% increase. The commission didn't do it.
Okay.
And that increase remained in effect for a long time. So we're asking that be corrected.
All right. And you just used the word, I think, about excess tax. If it's excess, who should get it?
Well, the excess tax is offset by the excess increases in costs. So if you come up with a final decision, even if we over-earned, there are cases that say you can't go back and take more money away from the customers just because they over-earned. But in this case, we did not over-earn, and I think it's improper retroactive rate making to then go back and say over the next 5 years, we want to give you, the customers, back money for one cost that decreased, ignoring all the costs that increased. If you don't ignore all the costs that increase, instead of giving the customers back $35,000, you'll be giving us $35,000 more money to make up for the shortfall. We're not asking for more money for the shortfall, and I think it's improper to ask for more money for one component of cost that's decreased. That's retroactive rate making.
All right. Well, I've only had a chance to look at maybe a page and a half of the contract, but in what I noticed is that you get a percentage. Excuse me. You get a percentage of the income that comes into the company. Is that correct?
Of net operating income starting in January 21, I believe it is, we are going to get a percentage, but that's not built into the rates. That's something the customers, the owners of the company are going to be paying for.
The owners are going to pay. I mean, it sounds like the owner's been putting a lot of money in there, and they're paying that separate and not the customers.
The owners put a lot of money in, and money that the owners put in to cover cash flow, and I think Terry Lee, the president of the company, probably has put in close to $400,000. That's not part of the rates. It's not being recovered by the customers. It was money that was put in to keep us from.
If you get a percentage, where's the incentive to lower rates for the customers?
The customers are not going to be paying for that percentage either. That's going to be paid for by the owners.
Separately
By the owners. It's not built into this rate increase.
Okay.
Nor will it be built into a future rate increase. This is something between the owners and me, because while the owners have put cash flow into this utility to keep it running, and Mr. Lee has put in $400,000 to keep it running, over the years I've put in $1 million to keep it running by delaying payments. So I told the owners, you know, fellas, I happen to be putting in more than twice as much money as you put in. I never charged interest on it, but I've reached the point where the cash flow is affecting John F. Guastella and his budget. So from this point forward,
If John F. Costella's losing money, why are you still doing it?
Because I know we're gonna succeed and make this a strong utility to serve the customers.
Okay.
And how do I know that? We had two appeals and the court basically ruled in our favor on 2 appeals.
Well-
I know rate setting,
Okay,
Commissioner.
well, I know Supreme Court, I've been a lawyer for 45 years. When a case is remanded, doesn't mean anybody wins, it means you gotta go through it again. So, I mean, I've heard the word win, cases were remanded if I read them correctly. The other thing that I picked up was whenever you or Michael or anybody goes to, Daufuskie on site, you get, per diem, you get all expenses paid, you get a free place to stay, you get mileage, I guess, from Florida or wherever you come from. That's part of the contract too. I think the question is, how many different ways is Guastella getting paid, or an affiliate of Guastella getting paid by this water company? You're getting
It's getting paid for
a
the
flat
management.
amount a month, you're getting a percentage, you're getting, you're also getting, subsistence pay. And when you testify, when you do anything, any of these reports, you're also getting a separate fee for that. Are there any other ways that Guastella Associates is getting paid by Daufuskie?
If you take all the ways that Guastella is getting paid to manage Daufuskie and do the cases, the only costs that mean anything to the customers are costs that are being included in the rates. And the only costs being included in the rates are the management fees, and at this point, the rate case expenses and the Sabre condemnation. Other than that, all the other incentive fees, all the delays in Guastella getting paid because of accounts payable to Guastella Associates that amounts to a small fortune, for which the customers have benefited because we provided the cash to operate the system to serve the customers. And if you go back to some of the reports that I provided on the capital improvements, you'll see the number of ways that we have saved the customers hundreds and hundreds of thousands of dollars. So the only costs, regardless of how much Guastella is getting paid, and I'm getting paid because of the services that I'm providing, not just to the customers, but to the owners. The portion that I'm providing to the benefit of the owners is not being passed through to the customers, only the portion that ORS and the interveners and you are going to be reviewing as part of this rate case.
But the rate case expenses are listed, and it seems to me a lot of them, Guastella Associates, is twice what lawyers are being paid.
I do more than twice the amount of work that the lawyers do. I mean, we put together all of the numbers and all of the calculations and the rate setting methodology and the testimony, and we examine all the cross-examination, and we provide discovery, 3,250 pages worth of 400 discovery requests. That's all done by Guastella Associates, and then we give it to the lawyers, and fortunately we have lawyers who are very careful about what they charge the utility.
Okay. There was a lot of talk about being able to attract investors. Even though it's a publicly owned utility, there are 3 owners. Do you have any stock in the company yourself?
No, I don't have any equity interest or stock or
Do they-
ownership of the utility.
Do they sell stock? Is any
me?
equity interest available?
I'm
Or
sorry,
is
I
just-
didn't hear.
or is it just 3 owners?
The stock is held by one company, the holding company, and that holding company is a LLC, and there are 3 members of the holding company. The president is the managing member of the holding company. And those are the only, if you will, investors in the utility through the holding company.
Do you own any property on Daufuskie?
No.
Okay. Thank you. That's all I have, Madam Chair. Thank you.
Thank you. Commissioner Carol Lee Williams?
Thank you, Chair Belzer.
Sorry.
I almost get to say good evening.
Good evening.
Thank you for being here. I am going to have a host of questions from all over the spectrum, but the first thing is, from what I've heard you say, tell me if this is right, there are 500 customers on Daufuskie and that are taking water and sewer and irrigation, and then 900 that are on using the availability fee.
Yes, I don't think there's quite 900.
Okay,
But it's close, it's about 840, I believe, or some number like that.
840.
Maybe 880.
800 and what?
Maybe 880 connected customers. I'm sorry, availability customers.
Okay, so my question is, it's about 500, and it's a little bit less than 900 for availability. About 500 for
Yes.
customers that are using and consuming, and about 900 or a little less that are charged the availability.
That's what I recall right now.
Okay. Let's see. Kiowa has come up in a couple of ways, and I just want to clarify it so it's clarified in the record. It came up the day that we held the customer public hearing, and as somebody from the area, I think I understand that we've been talking about two different Kiowas. There's Kiowa River that you provide management services to, and they probably get their water from St. John's Water Company.
Kiowa River Utility is only a wastewater utility. Kiowa Island Utility is both wastewater and water.
Okay.
And Kiowa Island Utility gets its water from St. John's.
Who does Kiowa River get their water from?
I think it gets it from the county.
Or wells?
No, they don't have, well, they
Okay.
don't have water service.
Okay.
They buy water from the county, I believe.
But the point of all this is you have a management service for wastewater for Kiowa River, correct?
Correct.
But you have consulted and provided advice for Kiowa Island. I think that came up in your discussion either with.
At this point, I have no involvement with Kiowa Island Utility Company. I think two different previous rate cases, I was the consultant for Kiowa Island Utility Company.
Okay, but when you were talking about 3,000 to 8,000 customers, was that Kiowa Island or
Kiowa
Kiowa
Island,
River? Okay.
yes.
I just wanted it to be clear because of the customer who called in who was confusing the two entities.
Okay.
Are there other utility companies that you have been involved with that are like this, that are, you know, separate physically, you know, the water access issue, the situation where they're not growing, where the size is limited? Are there others that you've worked with in the past?
Probably a number of thousands of small companies that are limited in growth. They're small. They have problems for small companies that have been the subject of regulators trying to solve for years. I've been on the NAIUC Water Committee when I was a regulator, the National Association of Water Companies. NAIUC has the Regulatory Research Institute, and they put in a report. I believe if it's not here, it's going to be discussed later. And in that report, incidentally, two of the board members of that NRRA report were former commissioners of the South Carolina Commission, looking for ways to streamline the rate setting process for small companies, streamline how you determine cost of equity and rates of return for small companies. This has been a problem for years and years. I have never seen any small company with the kinds of problems or the costs of going through a rate case for those thousands of utilities. This is the most unique situation I have ever seen or experienced, and I've been around for 60 years doing this.
And so I think you answered my question at the end. You have not experienced another utility from a management perspective like this one.
No.
Okay. Would you talk a little bit about the time frame between, and I'm not sure if it's 2005 or 2008 and 2015, when we have been provided with the management contracts? I know you've done this a little bit before, so I hate for you to have to reiterate, but from a management perspective, are the agreements that we see starting with 2015 similar to what existed prior to 2015?
There were no management agreements prior to the 2008 management agreement. When the utility was owned, it was Hake Point Utility Company, now Daufuskie Utility Company. When it was owned by International Paper, there was no management agreement. The International Paper people were the owners, but not really managing it. Everything was pretty much left to operators. And
Then my question is really about 2008 to 2015 in terms of Guastella and Associates.
Guastella Associates got involved in 2008, July 9th, 2008, when the utility was purchased from International Paper's real estate firm.
And was your management agreement similar to what we're seeing in the 2015 to 2021?
Yes, if I recall, the management agreement hasn't changed except for rates, that there's a built-in increase in rates based on a 3.5% a year increase and growth in customers. Growth in customers has been small, so it's a small piece. And the 3.5% was reasonable at the time. If you look at inflation today, the 3.5% is pretty low compared to that, but that's in the agreement, so that's going to be stayed. So the agreement hasn't changed. I believe there's 3 of them that were put into the record today, and if you look at them, you'll see they're all the same except the calculation of the rate.
Okay. And of course, we've been doing other things while we've had them on our desk, even though they're here. Would you talk a little bit about the growth in customers? Is there an incentive in the management agreement that relates to growth in customers?
It's not an incentive, but we estimated that for the growth in customers, our cost for billing and accounting and certain activities would increase. So we didn't take the total growth in customers and take it as a full percentage. We took, in the agreement, 20% of the growth in customers. So it became a very small number increase from contract to contract, from year to year, based on growth in customers. It's very small piece because there just hasn't been that much growth. And even if there is growth, we're only applying 20% of that growth.
I have a question about the condemnation. I have a question about why that property was sold at tax sale. Was that, and forgive me, I can't remember the year that happened. Was that happening while you were managing the utility?
Yes, there was a tax sale in 2010 that I think was consummated maybe in early 2011. When there's a tax sale, the county is supposed to send notice to the owners that there's going to be a tax sale, and they're supposed to post on the property that's going to be sold for tax on the property. They didn't send us notice, even though we informed the Beaufort County of our addresses when we were managing the company. They didn't send us notices, and they did not post the tax sale on the property. So we never knew about the tax sale until Mr. Morgan of the Office of Regulatory Staff said, you know that you don't own the property. And I did not know that we did not own the property. When we found out, we then I went through a preliminary process with the individual who purchased the property for a tax sale, which was $526.70. And at first he didn't realize what he bought, but then when he found out that there were utility facilities on it, he assumed that he bought the utility, which he did not. Okay. And we went through a whole case with the treasurer of Beaufort County.
Has Beaufort County explained why they didn't post it and why they didn't notify you?
It was a mistake. Beaufort County treasurer said it was just a mistake by the people who send out notices. And she testified to that in the last case.
Okay.
That only the land was sold, not the utility facilities.
Okay. I appreciate the extra background. Did you listen to the public hearing that we held?
I heard the results of the public hearing, and
Okay.
I did not listen to it, and I forget why. I think it may have had something to do with kidney stones, but I'm not sure.
Well, has anybody followed up as a result of what was testified to in the public hearing?
If-
Or would you like to respond
No,
beyond
no,
how you responded to
they would be
Commissioner?
followed up. We've been kind of busy doing other things, but we'll take a look at what was asked and if there were inquiries. It's my understanding that we never received some of the complaints that the customers voiced at the public statement hearing, but we'll take a look at those. We have answers for them. We know that the leak they were talking about had nothing to do with serving the customers, and it had to do with a leaking source of supply to a hose bill to clean out a wastewater lift station. Had nothing to do with the sewer system, the water system. But you know, customers see a puddle of water and they think it's the utilities water system
Right.
that's doing that. And it
But I
wasn't-
think customers also respond really favorably to just the facts and learn, being educated as to what was actually happening.
Most customers do. I
Yeah.
mean, most of the customers that we deal with are very reasonable. We have complaints, we resolve the complaints, or we just have inquiries and we resolve the inquiries.
Right,
There's only a handful that do not.
right. It's, if you need to know this, it's very easy to re-listen or watch that hearing again, in order to be able to follow up with those customers.
Actually, I believe Michael Guastella has observed
Good.
the whole thing.
Good, okay. Would you like to testify or send me to somebody else to talk about the salinity that was brought up in that, I believe in those hearings? Is that an issue that you're seeing in testing?
No, there's no issue with salinity in the Daufuskie Island utility. The water we're taking has no indication of any saltwater intrusion. So it's not even something that's nearby. The information we got, that it might take 50 years before the ocean starts to get close enough to anything to even possibly cause a salt problem. So it's at least 50 years away based on what we've seen from different reports.
I hope we're that lucky.
I hope so too.
Tell me about your rate for residential usage. I understand from what we can see that it's based on a minimum of 6,000 gallons per, and I've forgotten if that's a month or if that's quarterly. Why was 6,000 gallons picked? I realize that may have been quite some time ago.
The rate has two components: the service charge, for which there is no water allowance, and then and this is water. Then for all the water they use, there is a charge. I believe for the wastewater, we may be using 6,000 gallons, and beyond that, we may not be charging. But I'd have to confirm that. Let me just take a quick look so I don't have
I'm going to try to do the same.
make you wait.
And clearly, you may already know this, but there was testimony in the public hearing regarding incentivizing folks to conserve water, and what I'm looking at is residential rate based on 6,000 gallons usage. There's the base fee, there's a consumption fee, but the residential rate is based on it looks to me like 6,000 gallon usage, and there's a flat fee that everybody would pay. And then there would be the consumption fee.
There's a base service charge for wastewater. But
Is that the
also
base fee?
Base fee.
Okay,
But there's also a sewage base fee.
right,
And we do not charge for irrigation water to the wastewater customers. We base that on their domestic use. So it's not charging, in other words, people watering the lawn, the water's not going back
Right.
to the sewer utility.
either I'm misreading, this information, or I need to ask somebody else about the identification of the 6,000 gallons that,
Yeah, it's not unusual to see that. And utilities where they do not have separate irrigation meters, the user rates for sewer service try to recognize that there's an average consumption for domestic use.
I'm going to jump in and just clarify. What I'm seeing is residential, water. I'm not confusing
Oh.
water and sewer.
No, water is not, we don't have any limit or 6,000 gallon limit with respect to water.
Base minimum fee, it was my understanding. But I will go back and do some more research on this tonight.
Base fee is regardless of how much water is used. It doesn't, it's not based on the amount of water used. We do not give a water allowance in our service.
I've got my homework for tonight then.
Okay.
I want to just clarify some of the materials that I've seen and that you've testified to. You talked about the maps that were in your application, and they appear to be from July of 2007 from Thomas and Hutton. And those fit really nicely, I think, with what we were given in the Compass South appraisals in terms of the time frame, because there's not a year that something was installed after 2002.
What we did was we took a sample of water mains, wastewater mains, just a sample, not all the mains.
Okay. So the Compass South material is based on a sample and not the full installation.
Partially correct. The Compass cost is a per foot cost for today's cost, regardless of how much mains we had there. So what we did was we took a sample of how much mains we could wheel without wheeling the entire system and going through lots of time. But just on the small sample of the utility facilities related to Melrose, when we applied the current replacement costs and trended it back, it justified that the amounts that were booked were very conservative and very low.
Then I'm going to ask a different question. On the 2007 maps that you've given us in the application, does that reflect, as you were testifying earlier, to the full extent? Is 2000, would a 2000 map cover the full extent of Daufuskie
Yes, I believe
Island Utilities
I believe it
investments?
does. I believe it does.
Okay. I don't have much more for everybody in the room that's wondering. You testified eloquently with regard to the independence needed, or not needed, in your opinion, related to cost of service study. I want you to have that kind of discussion with me about the depreciation study that has been suggested.
The depreciation study is going to come up with average service lives. I think it's important to recognize that you cannot do one of these actuarial or retirement rate studies. There's just not enough statistical data to do that for a small company. And that's true throughout the country for all small companies, especially those, and most of them are originally related to developer-related utilities. So the kind of study that needs to be performed, if you're going to do one, is a comparable study. What are other utilities' average service lives and depreciation rates for comparable utility facilities? I do those studies, I'll say all the time, but not every job I have is depreciation studies. But over the years, I must have done 10 to 15 of those. And I don't think my depreciation recommendations were ever changed. And I have decisions from Arizona, New Mexico, Illinois, where they accepted my depreciation studies because I have a large database of what actuarial studies were performed for large utilities, what comparable rates were, what NARIC recommended rates are, and in the different regions of the companies, what their costs are. And if I find specific items of plant that need to be examined further, we take a look at the causes of their depreciation. And depreciation recommendations, and I think the last two are within the last 2 years. They were just accepted because the staffs of the regulatory agencies and the interveners of the regulatory agencies just had no quarrel with it. So to do one of these depreciation studies, I just don't know why any other consultant is going to have the database I have. And we know the utility better than other consultants. So if another consultant came in, they would have to have a learning curve to know what the Daufuskie Island utility is all about. We don't have that learning curve.
And I appreciate that what you're saying is you have deep experience across the country. You have precise experience in this location. And I want to ask about it from the angle of the value of an independent person evaluating doing the depreciation study. You gave me good testimony for why, with cost of service, independence may not be so important. I'd like to hear you say why having an independent, objective person is not important with this depreciation study.
I believe it was Discovery, but I'll be corrected if I'm mistaken. We provided my proposals for doing depreciation studies for other utilities.
Understood.
They range from 29,000 and more to do one of those studies. My last one was a small company, and we did it for $15,000. We're not going to find another consultant coming in and doing a depreciation study for $15,000.
And I really do appreciate that. What I'm trying to ask is, from an objectivity perspective, is there a reason that you do or don't need someone who is coming at this fresh? Is there, over the course of my career, I've been amazed at the things I haven't been able to see because they're just always in front of me. And so I wonder, I realize you bring a lot of experience to this study, but, and at a value that might be really good, but what if we miss something that somebody coming independently and objectively brings to it? Is there a reason why we don't need that with a depreciation study?
There's very little variation in looking at comparable average service lives and depreciation rates and taking into account salvage values. I've been through the expensive studies when I had to start from scratch with utilities. I've done all of that, and because I have models that do that and a database, there's nothing that's going to be a surprise for a depreciation study. We have average service lives for each kind of property and a range that another consultant is going to have to develop. I don't know whether they're going to have the same range as I have, but they're going to have to develop a range and then make a judgment. There's nothing that affects independence on that, whether I do it or somebody else does it. There's no new information about average service lives. I mean, depreciation average service lives have been around for close to 90 years or more. I've got studies that go back many, many years for hundreds of millions of dollars when we did our retirement experience. It no longer exists for the small companies. So I don't see a benefit for this independent. And I don't frankly know why they call for an independent individual doing a study. I don't know the reason for it, frankly. It's hard to fathom the reason for it. And I hate to say it, but I was frank with Commissioner Gaston. I'm going to be frank with you. It just seems that Guastella Associates is a rub.
Okay. I appreciate that. And this, for all the room to know, is my last question. This has to do with the Compass South evaluation. Typically, when there is testimony from, typically we receive testimony from the source that produced the analysis. And is there a reason why you are presenting that for them as opposed to from the source, Compass South Appraisals?
Well, as an appraiser myself, and as an expert in the field, I'm able to look at what another consultant would do in terms of valuing the current costs of property. I'm really doing it, as I indicated before, because we believe that the Supreme Court was looking for that kind of information to be inputted into the data that we already presented and the documentation we presented. ORS didn't do it, and we wanted to be prepared to do it if ORS didn't do it. So it's something that's typical of what I do. When I start looking and doing appraisals, we look for textbooks on construction costs, whether it's Handy Whitman or other means construction cost indices. I apply different sources of information to do a study, and those studies are accepted because I'm an expert knowing how to understand different sources of information.
Mr. Costello, thank you very much. No
you.
further questions.
Thank you, Commissioner Williams. Are we gonna, I mean, it's after 6. Do y'all wanna keep going, or do you wanna come back in the morning? Commissioners?
I got a couple of questions. Probably won't take about more than about 10 minutes.
Commissioner Justin Williams?
Sir, I applaud you for your endurance. I have a few questions. They're going to be a little bit different than my colleagues' questions. I've heard you say that the owners of the utility have invested their money into the utility. I think you've said about $400,000 for cash flow. Is that correct?
It's cash flow, but it's not an investment. The investment is the cost of utility facilities less depreciation. They just needed to provide cash flow for the utility to serve the customers because the impact of the rate increases were not enough for us to cover the cost of operations. So that cash that's has been infused into utility is not going to show up. It's not in this rate case, and it's not going to show up in any other rate case. It's just cash flow to keep the utility operating, and eventually we hope to be able to reimburse the owners for the cash that they put in, not because we're increasing the rates for it, but just through the cash flow that will result from rate increases in the future.
Right, I understand, sir, and I apologize for the poorly phrased question, but that cash coming from the owners, that's not the way the model is supposed to work, right?
No, it's rare that owners have to. I mean, if you take a look at the stockholders of big companies, you never see them going asking the stockholders to put them some cash to run the utility.
Right. And I'm understanding you're saying you're owed about $1 million?
I forget what the level is, but it's probably close to that now, yes.
Okay. So, I mean, it's not that you know, but just hypothetically, is there any risk that the owners may say, you know what, this is no longer a viable business for us. We're going to take our money and put it in something that's a little bit more stable, maybe. Do you see that as a potential risk? Or even you yourself, sir, you're owed $1 million and you're still here. Have you thought about just walking away?
No, I'm not going to walk away from that kind of accounts receivable. And I don't think the owners want me to walk away from it. We've been through a long process, and the owners they're not happy with the process, but they certainly are happy that we've been successful in appeals, which are very rare. And we know that down the road, we're going to have a utility that's generating a return on investment that's reasonable and only covering the cost of providing service. So I kept the customers from losing the utility from Coastal States Bank. We were able to get financing and keep the utility operating. They recognize that I'm willing to take even more of a chance with putting in cash flow or by not getting paid than they were by putting in cash flow. I don't think there's a chance of, the utility owes the money, so they can't just walk away from it. They're gonna have to do something with that utility, not walk away from it. And even if it gets sold, the proceeds are gonna have to go to Guastella Associates and then spread among the owners of the utility. But that's a story for another day.
Okay. I mean, do you think is it a good, is it worth buying? Or would someone be
think
buying a
so.
headache?
I think so. I think if you take an investor-owned utility, and I don't want to get too far into the weeds, but investor-owned utilities pay income taxes. Their rates of return are double what the cost of capital would be for a municipal type utility or district or association. There won't be depreciation because the debt service is going to be smaller than the return on investment a utility, an investor-owned utility has, and depreciation. They're not gonna have rate case expenses because they're gonna be a municipal type utility that's gonna be making decisions. There is a lot of cash flow that would flow to a municipal type owner of the utility. So is it worth it for them to buy? I haven't done the arithmetic, but I think it would probably limit, if not reduce rates, if a municipal type utility were to acquire this utility at market value, not at original cost less depreciation. And be in control of utility and generating probably millions of dollars of revenue rather than having to go through and provide returns on investment to a regulated utility.
Here's my last question, sir. You've been around the block a few times. Do you think there's any consultant out there that can provide the services for Daufuskie identical or similar to the services you provided?
No, I don't think there is. And I hate to say it, but I think the proof is in the pudding. We've allowed this utility to survive when it probably would not have otherwise survived. Right from the beginning with the loan to Coastal States Bank that had the assets of the utility as collateral. We've accomplished enormous amounts of savings to the utility. And this small utility happens to have had a consultant who knows rate setting inside out and what is the methodology and the principles of rate setting. If the large companies rarely take a regulatory agency on appeal, for a small company to do that, and I think it's successful when you have decisions reversed and remanded on 2 occasions. That's an accomplishment that I haven't seen any major utility or any consultant succeed with any other utility. And I have been around the block a lot of times for thousands of utilities.
Okay. I lied. I said it was my last question. One more follow-up. So, because the reason I'm asking this line of question is sometimes commissioners, customers, the parties don't know what the alternative is. So when you say you save the utility or there's no one that can do it better than you, what would have happened? What would have been the alternative if you wouldn't have been able to, quote unquote, save the utility?
It's hard to say because a bank getting a utility doesn't know how to run a utility. So even though Coastal States Bank formally filed for foreclosure, I don't know what they would have done if they got a utility. So I don't know how it would have affected service or what the consequences would have been. On the other hand, there were people who invested in this utility and they were not about to walk away from their investment. And they shouldn't have. So what the consequences, it's hard to say what the consequences would be.
So in one world, it would be a world of uncertainty. We just don't know. And then in the other world, I guess the world we live in now is we are where we are. That's fair.
Sums it up.
All right. No further questions. Thank you, Madam Chair.
Thank you, Commissioner Williams. Commissioner Thomas, you've been very patient. Thank you.
Thank you. I've been a little bit slow on my button. Apologize. Good afternoon, gentlemen.
Good afternoon, Commissioner.
So I'd like to start out talking just a little bit about your rebuttal exhibit JFG-1, if we could. Just trying to make sure that it's pretty clear what's going on here, and I'm not sure that it's very clear to me. And it appears to me that there perhaps are some inconsistencies or inaccuracies in some of the numbers. The first one that I'm looking at on the left-hand side under the sewer plant, you have the 8-inch.
I'm sorry, Commissioner, I'm having trouble hearing you.
That works both ways here.
Okay.
So I'm looking at the left-hand side under the sewer plant. And the first item under there says it's an 8-inch gravity sewer plant, and it's priced at $90. If I look at the document provided by your consultant, the number at the bottom of the sewer piping says 8-inch, it says force main, but it shows $98. So I guess I don't see documentation that supports the $90 that you have used. The $90 actually ties in with the 8-inch water piping, but this is sewer plant. So I'm trying to understand why.
Well, we used the $90 for both 8-inch water and wastewater. Probably a conservative number. So if we used the higher amount, our results would have shown even more of a conservative number for that which was booked. We wanted to be conservative with what the prices we were using.
And then if you look at the bottom of the sewer plant list there, the 10-inch effluent main, it's priced at $92. And again, you look at the documentation that's attached, the 10-inch relates to a water piping. It just doesn't make a lot of sense to me. It just seems to me that things should be consistent. There should be documentation backing up the numbers that you use, whether it's conservative or not, or the other way. It just makes it hard for me to follow the reasoning here. I think that's important. If you could help me, whether it's conservative or aggressive or what, just follow and understand why it's the way it is, why this is your exhibit.
Commissioner, I'm looking for the exhibit that has the Compass South appraisal information. I just don't have it in front of me. If I can get a copy of that.
Mr. Gressett, would you like to give him his exhibit JFG-1?
Commissioner, you're correct. We used the prices that were lower for the water main installations, which doesn't change the results of the analysis in terms of the total results. It simply was numbers that we took off of the summary page, and apparently we took the water main information and used it because it was
I'm having a hard time hearing you.
Yes, the difference is we use the $90 per foot for the 8-inch water main instead of the $98, which is correct. We did do that. Had we used the $98, the numbers would have been greater. So that was just a decision we made to be using the lowest estimate for price per foot of installing main.
So if that was a purposeful decision, it would seem to me that that should have been footnoted so it would be obvious to somebody else that's trying to review it. Would you agree with that?
It probably would have been more obvious, but I should have mentioned that in describing what we did as being a conservative approach rather than a less than conservative approach. Either way, the numbers would have proved that the cost booked were reasonable.
And then if you look at the middle there, you look at the 2-inch force main, you have $22 in there, whereas if you look at the attachment, that should be $23. I guess it's the same explanation, but if you want to go through that again, then that's just fine.
Yes, same explanation.
All right, and then if you go over to the other side, the vintaged cost, again, just to make this a little bit simpler to look at and follow, if you look at the vintaged cost, you see a lot of numbers there in boxes, but there's no total. If you total those up, they come to a number that's, you know, mentioned in your testimony and whatever, but it's just not a spreadsheet that just kind of helps a lot of people follow what's going on. I mean, would you agree that this is kind of strange way to do a spreadsheet?
I agree it would have been clearer for the reader. We're involved in this, so when I look at numbers like 200,000, 795,000, 529,000, and $900,000, it brings us higher than the cost of all that was booked for Melrose. So, my eye looks at it and say, with those kinds of numbers, clearly what was booked. I suppose we could have had the total numbers, which would have made it easier for the observer to understand.
And then if you look at the cost per books, again, there's no total there, which again, to me is an important number, but it's not there. Any thoughts on that?
Yes, if you look at the cost per books for only a portion of an 8-inch water main is $210,000, but all of the water mains booked was $100,000. To my mind, there's not a reason to go further. And when you look at the cost of the sewer mains at $765,000 compared to the booked amount of $62,000, and if you look at the other numbers, $29,000, $529,000 for the Boiling Point treatment facility compared to $188,000. I guess I look at that and it's just so clearly obvious to me that the book costs were so much less, even on a less than full sample of facilities, that I guess I shouldn't assume that what I look at is so very obvious to me, because the numbers, the individual numbers, just far exceed what the book cost would have been.
Well, would you agree that the reason that you're here and testifying is to put evidence into the record that is understandable by the other parties and perhaps us?
Yes, I would assume that you could look at this as I explained it and understand that the book cost was so conservative compared to the sample facilities that were priced at the reproduction cost and trended back. I think it's clear enough, but could have been clearer.
Well, and I just want to make sure, I mean, we have to weigh all of the evidence, and I want to make sure that you have your opportunity to put the evidence in the record that's accurate and that other people can understand and follow. Otherwise, we can't really use it to make a decision. So that's why I'm asking these questions. Can you appreciate that?
Sure.
And so I have a couple of more questions about this. So the Handy-Whitman indicator was used, and also your consultant referenced the Marshall and Swift valuation. And I know those are two different things. But again, could you help those of us that are not as knowledgeable as you to understand the difference between those two?
Yes, the Marshall-Swift is a method of determining costs. The Handy-Whitman index measures the changes in costs over the years. So there's a significant difference. Marshall-Swift would give an appraiser an idea of what the costs are. The Handy-Whitman will give you the change in costs over a period of time.
Okay, and you said earlier that the Handy-Whitman does not factor depreciation in, correct?
Correct.
Okay, so we're looking at the gross number here, not a net book value. Is that correct?
No, net book value is cost less depreciation. The original cost is what we're looking at that was priced at today's replacement cost. And the Handy-Whitman is looking at what would the original cost be in the year of installation. So we're talking about the original cost. If the original cost justifies the amounts that were booked, then depreciation is going to be applied to the book cost and not the replacement cost trended backward.
But in the end, the net book value is what goes into rate case. Is that normally the way it works?
Cost less depreciation what goes into rate base, yes.
Correct. That's my understanding. So that last column doesn't reflect what would end up going into rate base. Is that correct?
It shouldn't. We're trying to establish the booked cost, original cost, as being reasonable. Once we establish that, then the reasonable book costs are going to be depreciated, and that's what's going to go into rate base.
Okay. So let's talk a little bit about the excess deferred income taxes. I guess I'm having a little bit of a problem in trying to understand why Daufuskie should be treated differently from other utilities. I mean, generally speaking, the excess deferred taxes has been going back to customers, and you're saying that's not the right thing to do here?
Yes, I'm not interested in knowing what other utilities will do that's wrong. I'm interested in presenting what's correct for the Daufuskie Island Utility Company and rate-setting principles and methodology. What's correct for rate-setting principle and methodology, which if other utilities are not doing it, they're remiss in not doing it. But it's retroactive rate making to take a fixed rate and then in the future have the utility reimburse for one cost that decreased. That's retroactive rate making. And then not to consider increasing and charging customers more for the increases in costs that were not included in the last rate decision. So there's two components. One is it should have been offset by the cost that increased. Once that happened, then the commission would not allow cost increases from the past to be part of the prospective rates in this filing because it's retroactive rate making. It's therefore also retroactive rate making to take a cost that decreased in the past and make up for, and in this case, give back to the customers, which would have created more of a loss in full return or deficiency in full return than the company actually experienced. So this adjustment would say the company didn't experience the full return that we gave it. They have to live with that because this is permanent rates, and for the future they just have to live with not earning the full return that we allowed. By doing the tax adjustment prospectively and giving customers back money, that increases the shortfall in earnings that the utility experienced. It's not only retroactive rate making, it's an unfair retroactive rate making.
It seems to me that you're mixing up a couple of concepts here. Excess accumulated deferred taxes is one thing, and under-recovered other expenses is another thing. And that's why these sorts of things are in different accounts in the chart of accounts and on the books. You don't just wash things back and forth against each other when you come in for a rate case. That's not a concept that I'm aware of, period. Please help me understand.
It's difficult for me to explain more of what I just explained.
Well, then let's just move on.
Okay.
All righty, and let's talk a little bit about ROE. And you use 3 different methodologies with not a whole lot of backup to support your numbers. And you've been asked about the discounted cash flow and the CAPM, and you don't think those are applicable to the small utilities. But there are other methods that are perhaps possible too. I mean, have you ever thought about the comparable earnings model?
Also not applicable to a small utility to reflect the sensitivity to earnings erosion that I described in pretty much detail. And I think when you take a look at the Federal Power Commission versus the Hope Natural Gas Company, 320 U.S. 591, the Supreme Court said that the utilities must be given enough revenue to cover operating expenses and the capital costs. And on the capital costs, they explain that those must be commensurate with investments in other utilities and enable the utility to maintain financial viability and attract capital. With the return on equity recommended through those CAPM, discounted cash flow methodology, or the other methodology, they do not take into account the sensitivity to earnings for many, many reasons. And there is not a chance ever that those returns would enable some market-based investor to invest in the Daufuskie Island utility instead of the proxy group of companies that are used for those methods. So basically what the cost of capital witnesses are saying is, we're going to give this utility the same return on equity that the large companies get, but there's not a chance that an investor would buy this company's utility, attract capital, as opposed to investing in the large utilities. And then I go through a whole series of the problems that a potential investor would look at. No dividends ever paid, a shortfall in earnings, a 7-year rate proceeding, 2 appeals, and having to require, if you bought the stock, become a guarantee of the loan that the Daufuskie Island utility has. Massive difference, not just a little difference, a massive difference. So the cost of capital methodologies that you refer to have absolutely no relationship to the small companies, and none of the companies, the thousands that I've been involved in, either directly or indirectly, would survive under that kind of, would be able to attract capital as opposed to survive, be able to attract capital, because they can't compete with the large companies using the models that you're referring to. It's just not reasonable or possible.
Okay, thank you. So the basically the reason for filing rate cases, one of the basic reasons, it seems to me it's always been, is to make up for earnings degradations, as you call it. That's kind of been my understanding of how rate cases work and why they're filed. That's one of the big overlying concepts. Would you disagree with that?
No, I agree with that, and that's the cost of providing service. What does it cost for your operating costs, and what is a reasonable return that a small company could get given its sensitivity to earnings? So I don't disagree.
Okay. And we've talked just a little bit about the cost of service studies. And at one point early on, you, let's see, what did you say? You said that the fair allocation of revenue between customer classes isn't going to make any difference to the overall revenue requirement. But if you're a customer in one class that's subsidizing another class, at that person's perspective, do you think it would make any difference?
If the study shows that there should be more cost recovered from one class compared to another class, then certainly the customer that gets the benefit of the reduced rate for that class that it's in would make a difference to that customer. It's not going to make a difference in terms of what the total revenues the utility is going to receive. So from the utility's perspective, if the commission or ORS or anyone else wants to do a study that changes the rates up and therefore offset by down for the customer classes, there's no bias involved. The overall revenues are going to be the overall revenues from the customers as a group. So everybody should do the best job they possibly can to allocate the costs so that each customer class pays as fair as it can. And by the way, these customer cost allocation studies, it's not straightforward arithmetic and you come up with an answer. You only come up with an estimate because you have to allocate plant designed to serve different customers, all based on judgment. You have an average load, you have a peak load for max day, you have a peak load for peak hour, you have customer costs that don't change regardless of how much water a customer uses and doesn't use. So you go through a series of judgments, and they're judgments. It's not strict arithmetic where if you do this arithmetic, you come up with the answer. It never happens that way. And then after you're finished with that, then the regulatory agency could say something like, well, we want to encourage conservation, so we want to change the rate structure regardless of what the cost allocation study came up with. So this is it's more a science than an exact calculation. So the cost allocation studies are going to come up with recommendations for costs, but if the commission says, this is what the costs show, but we would rather you apply more cost to irrigation because we really want to send a message to those customers using a lot of water to use less water for a conservation effort, it'd be done, and nobody's going to argue with you because that's going to be a commission policy to what's in the best interest of the different customer classes. So there's no bias involved in doing one of these studies that would require some independent look at the studies.
I understand that. And again, we're not talking about just from the utilities perspective here. We're trying to understand it from all parties' perspectives. And the allocation of costs appropriately between customer classes is something that we need to take into consideration. Would you agree with that?
I would, Commissioner, and of course, if you raise the connected customers' rates, you're going to get a lot of customer complaining about the rates. And if you raise the availability customer rates, you'll get some of those customers complaining as well. It's a revenue neutral calculation. You're not going to make all the customers happy. You're going to make some happy and some unhappy. So we'll do the best job as we can to recommend the best combination of rates for the different classes of customer.
We're just trying to be fair to everybody.
I agree.
And the concept of estimates goes throughout just about everything we've talked about here today. It's not an estimate based on cost of service studies. It's estimates based on depreciation, useful lives, goes on and on and on. So to me, that's just a concept that is part of accounting and rate making. Everybody thinks you just add numbers up, but it goes beyond that. Would you agree with that?
Yes.
All right, let's talk just a little bit more about the tax sale, please. You indicated that, I'm trying to paraphrase here, you did not know there would be a tax sale. And it's no fault of our own. Those are two phrases that I think that you used. However, your company is the one that's supposed to be keeping up with the accounting records, and keeping up with tax records is part of that, and paying tax bills is part of that. You didn't need to have somebody else come in and tell you that that property was going up for sale. I would just think that it's part of your normal record-keeping process to be sure that you're watching what's going on with taxes, to make sure that you're paying your tax bills. Is that a flawed assumption, or am I off base there?
Well, we do keep very close watch over our costs, our taxes, how they're booked and what they're booked, and what we receive as tax bills. And what we receive as tax bills is what we book and what we pay. But when you don't know what the county is doing in terms of a tax sale, keeping books is not going to tell you. Keeping the best books possible is not going to tell you. If they decide to do a tax sale and don't send the utility a notice of that, we have no way of knowing. Whether or not we keep the books perfectly or slightly imperfectly, doesn't matter. They didn't tell us what was going to happen. And, you know, we can't predict things that are where information is not provided to the utility, nor could we find it because of how we're keeping books. No way to find that.
Well, that's a little bit different from my experience. My experience is that you can go to a county website and see exactly what's being billed. You can see exactly whether or not, in the county's opinion, it's been paid. You don't have to just rely on getting notification by mail or email. That's just the way things work these days. Anybody think about reviewing the records against the county tax records? It's publicly available. I mean, would that not be something prudent to do?
I don't think there's anything prudent to do to have learned about a tax sale that we don't know about, that the utility didn't receive any information from the county.
Madam Chair, I'd like to ask Commissioner Thomas if he would yield for a couple of questions.
Sure. I think I'm through. Let me just take a real quick look here. I've pretty much hit the points that I had in mind, so sure.
Thank you, Commissioner Thomas. So you know that as a matter of due process and notice, if you did not receive notice, you could have had your attorney, or you could have prepared your own affidavit saying that you received no notice of the tax sale and moved to set aside the tax sale before the master in equity of the circuit judge in your county of service. Isn't that right?
And it was done. But then we
It
found
was
in order to,
done.
I'm sorry?
What was done?
We did move to change the tax sale. However, we found that the time it would take to change the tax sale and the cost of doing the tax, of arguing with the county to change the tax sale was not the best method to go. That condemnation was the better, least costly method to go at the time. So we did do all of that.
Well, let me tell you this. I was a circuit judge in South Carolina for decades, and I can tell you that any taxpayer that showed that they received no notice of a foreclosure sale was immediately set aside as, you know, and that's the rule of law, and that's a part of our statutes. So you knew that. And if you didn't know it, you were negligent in not knowing it. I'm waiting for your answer.
Well, when we found out about it, we contacted our attorneys to see what we could do to change it. And the reason we had to change it is because the bank wanted to have title to the land in the hands of the utility. It didn't happen, and I believe there are decisions in the last rate case that recognize and possibly even at the Supreme Court level, and I don't recall whether it was oral argument or in a decision, where the Supreme Court actually said they didn't know it happened, so there was testimony by the treasurer of Beaufort County that said that what was sold to the utility, to the Sabre, was just the land. It wasn't the utility facilities. So we've pretty much gone through this process, that it was beyond the control of the utility. I appreciate that maybe
I'm sorry,
we could.
but I don't buy that explanation. Any lawyer that practices property law, tax law, would be able to clearly set aside that foreclosure sale, rendered it null and void, and all you had to do was pay the taxes that were due, less any penalties and interest. And you chose not to do that. And I think that's negligence is a matter of law. If you were advising this entity not to challenge that foreclosure action. Now, my next question is, we've heard that you fudged the numbers on these accounting information. Commissioner Thomas's questioned you about that. Why are you doing that? Why did you not give us true and accurate information?
We did give you the information. What we used for being conservative was what we used, but the information was provided to all the parties. So we gave you the information and we used conservative numbers. I don't think that's fudging anything.
But the information that you gave us was not complete and not accurate, was it, sir?
The information we gave you was complete from what we have, and it was accurate from what we have. The way we
But
used
the information you gave us does not meet standard accounting principles, did it?
Well, there's no accounting principles involved in doing an estimate of vintage prices to check the book costs.
Well, that's news to me, because I thought we followed conventional accounting principles when we talk about imposing a rate increase on your ratepayers. You don't follow generally accounted practices in your work?
Maybe I'm misunderstanding. What issue are you referring to, Commissioner? Are you referring to the?
I'm referring to all you just answered Commissioner Thomas's questions that the numbers you gave us were incomplete and inaccurate. And I'm asking you, why is that? Is it because you have $1 million stake in this case to recover your fees?
Commissioner, are you referring to the rebuttal exhibit JFG1 that I was questioned about? That is the vintage cost calculation. Every other number that we provided were from the books kept in accordance with the Uniform System of Accounts published by NARIC. There's no fudging in any of those numbers. All of those numbers have been examined in detail in the course of the investigation of this case through the Office of Regulatory staff. I thought I was addressing the vintage cost analysis where we used a conservative number, which has absolutely nothing to do with fudging numbers on our books and records.
Madam Chair, I have no further questions. Thank you.
Thank you.
Madam Chair,
Commissioner Thomas?
just one follow-up question on that JFG1. I mean, we've already talked about it. And, as you have talked through it here, then you've made the pitch that you did this just simply to be conservative. That's what I'm hearing. However, that was in no way indicated in the exhibit that you provided to us. And again, I think it's up to you to help us understand so that we can make good decisions. That's the only reason I was asking those questions, just trying to make a good decision. Wanted to give you the opportunity to explain. Either you made a mistake or you did it to be conservative. I don't know which. You given those two answers. Do you want to talk about it anymore?
I don't object to your questioning anything that we've done. I've explained what we did and why we did it, and being conservative and using numbers that would have made it even more evident that the book cost was reasonable, to me is not confusing the issue, although we could have explained it, and maybe that would have been more helpful. But I look at this exhibit as an expert in utility rate setting and valuation and appraisals. And the truth of it jumps out at me. You take a look at the individual numbers compared to the book numbers, and the individual numbers show that the book numbers are so far conservative that whether we use $2 more for an installation of main or not would make absolutely no difference. In this case, it would have made it even more reasonable. But, you know, you reach a point of reasonable where it's so obvious to me, and I thought it would be obvious to anybody looking at this, that this is exactly the justification that the Supreme Court was looking for to establish that the book cost for the utility facilities was reasonable, over and above the documentation we already provided in the previous case.
Thank you, sir. I appreciate it.
Thank you, sir.
Commissioner Caston has 2 questions.
And she stuck her fingers up to me too and said, 2. I know you're tired, Mr. Costello. I am too, and I apologize.
I'm here for you, Commissioner.
Yeah, my mama used to say that too. Yes, ma'am. I want to make sure I understood on the capacity of the wells. 75 million, 200 million, 75 million, 25 million, about 100 million a year. Is that the firm capacity or the DHERC permitted amount?
The permitted amount of, my best recollection is 75 million, and we're only generating, I believe, somewhere around $30 to $35 million of water consumed by the customers, including whatever unaccounted for might be in that. So if we're only delivering to the system about 35 million compared to a $75 million permitted gallon permitted capacity, we're pretty comfortable that we're a long way off based on the small growth in this utility system in terms of connected customers. We're far away from getting near the permitted capacity of the water system.
I understand that. And what I wanted to make sure I had, because it gave me time to kind of just run through some numbers. And I think you'd said 450 customers average about 6,000 gallons a month. That's the ones that physically have meters and use it. And about 250 irrigation customers use about 117,000 gallons a year. And a total of 1,400 customers, which include whatever the difference between that 450 and that is of availability customers are got a meter, but they don't use it.
They don't even have a meter, Commissioner. They're just there.
They don't have a tap or anything at this point in
I
time.
believe there are service laterals extended to the property line so that if a customer wants to build a home, I believe it's there to be built.
But they're guaranteed that availability when they need it.
Yes.
All right. So my question is this, and I want to make sure I did it right. That's why I was asking those things. When I look at those numbers, and I believe you have to plan on 1,400 customers. I mean, there could be a boom next month, next year, 2 years from now, and everybody goes and builds on Daufuskie Island and fills those things up. The availability is allotted. So it would be 1,400 times 6,000 gallons a month on average. And then if you throw the 250 irrigation customers in there at 117,000 gallons a year, and I would like for DIUC and ORS to check the numbers, because that's not my job. Don't even mean for it to be. But if those numbers are accurate, that puts it at about 130 million gallons a year. And if you have a firm pumping capacity or a permitted pumping capacity of 75 MGD or 100 MGD, it appears that DIUC has allocated more than they have to give. That's all I'm saying. So I think that would, if those things are correct, it would cause me concern. Well, it does cause me concern. If I did it wrong, I'm used to doing things wrong, so that doesn't bother me. But just in case, I think that someone needs to, follow up on that. That's all. Thank you, sir.
Thank you.
Thank you, Commissioner Caston. I'm sure you have redirect.
I just have one question.
Just one.
Yes, ma'am.
Okay. And you want to go forward?
Yes, please.
Okay.
Mr. Guastella, when you were talking about 5:30 about the reparations appeal and the previous orders, I understood you to say several times that that case was still open and that was the difference. And then at one point you said the March 2021 order was final. Was that a misstatement?
The March 21 was final with respect to 108.9% increase. It was not final with respect to the reparations issue. That was held over for consideration subsequent to that March 21 effective date.
That's all I got.
Thank you. On that question,
That question. Mr. Costello.
get to the microphone, please.
Mr. Costello, Mr. Gressett just asked you a leading question, didn't he?
I claim not to be an attorney.
How did you answer?
I answered truthfully.
Okay. What did you say as your answer?
I said that the March 1, 21 rate increase was based on the 108.9% rate increase, but that settlement included provisions for further keeping the case open for further review.
Got it.
Thank you. Mr. Costello, you've had a long day. I'm over here. I'm over here. Thank you very much. You may stand down.
Thank you, Commissioner.
Mr. White, we'll see you in the morning, I suppose. Same chair, or you can switch chairs if you like. Anything else before we recess for the evening?
Madam Chair, are they still sworn in and under oath?
Well, we will re-swear Mr. White tomorrow since he did not testify today. Mr. Costello is dismissed from the witness stand, so he's no longer under oath.
Chair Belzer, you referenced discussing tomorrow with the witnesses a rate case expense exhibit.
Yes, it's attached to Mr. White's, I think, rebuttal.
Okay, thank you, Your Honor. And then it would be very helpful to us if we could take Ms. Multari first tomorrow. I think I'll have 2 or 3 questions for her. I don't think any of the other lawyers have questions for her. If we could take her out of order first thing.
You can call her first if you like.
Thank you so much.
And what about Mr. Rothschild?
He will be available whenever. We can go in the normal order. That'll be fine.
We will recess until 9:30 in the morning, 9:30 a.m. Thank you. Have a good evening.